May I please, Lachi? I beg to mention. I beg to mention item number 1. Was yes, but the engaged counsel SK though is coming from Guwahati, and subsequently he is on the way. So kindly pass over for the time being. He's on the yes, Mr. Master. I love.
Lordship, I would like to mention item number 11. Yes. Matter may be taken up after vacation. Yes. We have informed the PP also. We have taken consent from the PP. Matter may be taken up after 3 weeks, after vacation. You do some personal living.
Washing on settlement, right?
Yes.
Okay. On the prayer made by your name, please.
S. Iram.
S.
Iram.
Rina.
Iram.
Okay. Learned counsel appearing for the petitioners. All the 3.
Interim order is there, Lordship.
Okay. Interim order to continue until then.
Highly obliged.
May I please, madam? So I beg to mention item 26 of the hearing list.
Oh, there is a hearing list.
Yes.
There's
No, in the
hearing-
same course list.
Oh,
Hearing
yes, yes.
item 26,
26.
hearing column. The matter became is infractions. So I like to withdraw the matter.
Okay. So heard,
R-secure.
it is in relation to what? Is it in relation to the sitting MP MLAs?
Yes, yes.
20.
He has been acquitted by the trial court.
Oh. Heard Mr.
R-secure.
R. Saikya.
Yes.
R. Saikya appearing for the petitioner. And PP is there.
I have intimated the special PP.
Okay. Okay. And then Mr. R. Saikya stated at the bar that the matter has become infructuous. Full stop. As such, the matter is dismissed as withdrawn. Disposed of as withdrawn.
All that.
May I please?
Why infructuous? 1 second. That he is acquitted.
Yes, he is acquitted.
Okay.
Acquitted.
Infructuous. Since he was acquitted by the trial court
Yes.
of the offences that are challenged here.
Yes.
Yes.
May I please, Your Honor? Your Honor, I beg to mention item number 28.
28.
Yes,
Okay.
I have taken consent from the other side. Matter may be kindly taken after a week, ma'am.
After a week.
Yes, ma'am.
Okay. As prayed for by Mr.
M. Dojim.
M. Your name is there.
Yes, Margadi. Reflected is Margadi.
Margedi. Okay. Mr. Margedi appearing for the petitioner. It's difficult to pronounce the names. We are not very used to. So as prayed for by Mr. Margedi appearing for the petitioner, let the matter be listed after a week.
All right.
May I please, Your Ladyship? Your Ladyship, I beg to mention item number 10. Your
Which?
Ladyship, 10.
10.
Your Ladyship, I beg to withdraw the criminal
Why?
petition as the party does not want to continue with the proceedings.
Acha. In the entire case, we want to withdraw.
Yes, Your.
Why he doesn't want to continue?
Your Ladyship, I have
Washing of the FIR.
Yes, causing of the FIR.
Okay. Acha. Okay. And heard Miss
P. Lomdak.
Priya Lomdak.
Yes, Your Honor.
P. Lomdak for the petitioners. And
I'm for this additional PP, man.
Okay. And additional and heard and also Mr.
Theater.
T.A.T.
Yes, ma'am.
Easy. T.A.T. The additional public prosecutor for the state of Arunachal Pradesh. Miss P. Lomdak states that that the petitioners does not want to continue with the petition. As such, she has prayed for withdrawal of the same. The prayer is allowed. The petition is disposed of as withdrawn.
Highly obliged.
Obliged. May I please?
Yes.
Well, this is a civil revision petition, my lord. Challenging the my lord order dated 21/5/2025, whereby the my lord This prayer for condonation of the delay of 155 days. It will be an appeal. So,
Why was it rejected?
my lord, saying that the reason assigned is not sufficient. The reason assigns were, my lord, first medical
Acha.
and some lectures on the part of the engaged counsel also.
Hmm.
That was the reason. And the applicant is aged 63 years old. person. So he is suffering from various ailments. So medical documents are also there.
But then it was not
considered.
considered. How many days delay?
185.
185.
So it is
Let the notice go.
basis.
Heard Mr.
Arsenal.
R. Sonar, Rajesh Sonar, for appearing for the petitioner. And Mr. R. Sonar states before this court that there has been a delay of
85 days.
85 days in filing the incident. There has been a delay in filing the appeal before
District judgment.
district judge. Appeal before the learned civil judge, senior division.
No, my lord, appeal against the judgment and order of the civil judge to the
Okay.
district judgment.
No, just cut it. I'll read it. This instant petition is filed against the judgment dated 24/4/2024, passed by the learned civil judge senior, 24/4 passed by the Court of District and Session Judge, Sessions Division, Pasighat.
My lord, impugn order is 21/5/2025. my lord.
21/5 against the order dated 21/5/2025, passed by the District and Session Judge so-and-so, by which the learned court refused to condone the delay of 183 days,
85, my lord.
85 days in filing the said criminal
Title appeal number,
case,
my lord, in title appeal number 6 of 2024.
in title appeal number 6 of 2024.
Yes.
The grounds taken for for condonation of delay was that the petitioner, who was of 63 years of age, was suffering from various ailments. Full stop. A number of medical documents were also annexed with the same. However, the learned court below had a learned court below held that there is no proof of sufficient cause. No, wait. No. There was no proof of sufficient, there was no proper documents. There was no proper document showing the medical ailment of the petitioner. By looking into the documents, the learned court below further held that the applicant was fit, though he was advised rest. The learned court as such returned a finding that if he was fit, then why was he advised rest? As such, the learned court did not condone the delay on the medical ground. Assailing the said judgment, the instant CRP is filed. by taking the ground that the petitioner was 67 years.
My lord.
Oh, you correct it, huh? 63. 67. That time it was 63, perhaps. On the ground that the petitioner was 67 years of age, suffering from various ailments, including diabetes, severe back pain, high blood pressure, kidney infection, and as such, he could not file the appeal due to his health condition. The counsel for the petitioner also raises the ground that there was some negligence also in the part of the appearing counsel who had taken the responsibility to file the appeal. Issue notice to the respondents by registered post with AD within a period of 5 days, 3 days from today.
Well, so far this engaged counsel is cancelled instead of negligence matter because 1 month's time taken by the engaged counsel to file the appeal because some documents were insufficient. So that negligence on the part of the counsel that may not be observed.
Okay, then cut that line. Only on medical grounds I'll
By
get it.
that point. Give you that.
Let's this matter after 3 weeks.
May I please, your lordship?
Yes,
Lordship, this is also
similar kind.
similar kind, but the grounds here are that there was a kabang. A kabang, if your lordship knows, may not know, I don't know, it's a village council, which is also a civil court. Now, as per the Arunachal Pradesh Civil Courts Act. So there was some kabang. After that kabang was held, there was some finding in the kabang that this matter will not be dealt right now. There's a committee formed. There's a land dispute. The committee will look into the matter. The other party did not obey that, and there was a second kabang which this petitioner did not attend. So
Here one they did not attend, the next one you did not attend.
no, they did attend,
But
but they did not follow through.
Oh.
So it was actually without jurisdiction. Anyways, the petitioner had filed a title suit, but that was rejected on the ground of res judicata, saying that the second covers that. Then thereafter, he filed an appeal against that second kabang. That was in 2021. Thereafter, he filed an appeal against that appeal. The certified true copy was not given because, your lordship, even if they are civil court, they are village councils. Mostly, they are being the presiding officers are the village gaumpura, so they don't have this concept of certified copy. The situation was so bad that he tried to obtain, he could not get. Many times he approached. Later on, he had to file an application under 151 CPC for a direction to give him the certified copy. That certified copy was finally obtained and appeal was filed. Taking all these things into account, there was a huge delay of 824 days, but the the appellate court refused to condone the delay, saying that there is no sufficient, even though that order of that the district judge saying that you give the certified copies, there was also annexed in the appeal, in the appeal petition, in the condonation of delay petition, but that was rejected. So therefore, this revision. Notice may be issued.
notice.
Yes.
This is Kebang's decision.
Order is by the
Huh.
Civil Judge Senior Division, dated 26/5/25.
Yes. Yes. Okay. Heard Miss
And Duncan?
and Tagia.
Duncan.
Dange.
Duncan.
And Dange. For the petitioner. This petition is filed against the order dated 26/5/2025, passed by the Court of Civil Judge Senior Division, Pasighat, East Siang District, by which
In Miss Case number 30 of
Uh,
23.
in Miss Case number 30 of 2023, in Civil Kebang Appeal number 130 of 2023, by which the learned court was pleased to reject the condonation application filed for condoning the delay of 729 days.
824 days, but
Acha.
it was a finding that
Okay.
729 cannot be condoned.
Ah.
Application was for 824.
Let it be 729
Yes,
since
yes,
it is
yes,
recorded
yes,
here
yeah.
for 729 days in filing the appeal against the impugned Kebang decision of 1/2/2021.
Yes.
The main ground for refusal of the said condonation application was that there was no sufficient, the main cause, right, that the copy of the Kebang decision was not received, was not received, cannot be a sufficient ground for condoning the delay under Section 5 of the Limitation Act. It was further held that the applicant did nothing for around 2 years and 2 months from the date of Kebang decision dated 1/2/2021. And as such, it was held that there was negligence, there was bona fide negligence on the part of the applicant, full stop. The counsel appearing for the petitioner, however, states that there is enough reason for the said delay inasmuch as the petitioner was never furnished a certified copy of the impugned Kebang decision dated 1/2/2021 despite several requests. Unable to obtain the this doesn't have a wheel, right? Ouch, it's okay. There is. Unable to obtain the said certified copy, the petitioner filed a miscellaneous application before the district judge under Section 151 for a direction to furnish him a certified copy of the Kebang order, and that the same was furnished to him on 2nd of May 2023. And as such, the delay of 824 days was caused in filing the appeal. Full stop. Therefore, the counsel for the petitioner states that there was no negligence on the part of the petitioner in the delay caused. Full stop. Notice issued to respondent number
3 respondents.
respondent number 1, 2, and 3 by registered post. Issue notice, notice issued bola na. Issue notice to respond number 1, 2, and 3 by registered post with AD, returnable within 3 weeks. Steps to be taken within 3 days from today. List the matter after 3 weeks.
Oblige.
Kebang is a new concept I've never heard before.
Yes.
May I, Your Lordship?
Yes, this is a bail application.
Yes, Your Lordship.
He has been inside since?
Your Lordship?
He has been inside since
14 months, Your Lordship.
14 months.
Yes, Your Lordship. 1 year, 2 months, Your Lordship.
What are the charges?
Your Lordship?
Charges?
Charges against the accused POCSO, Your Lordship. And
366.
IPC 363/366A, 376DA of IPC, read with section 6 of POCSO Act.
It's going on.
Going on, yes, Lord.
Witnesses,
Witness has been examined.
how many?
There are 3 witnesses have been examined.
Acha, acha, acha. So let the scam records be called for.
Your Lordship, here another case arising out of same affair is pending before this honorable court
Mm.
by name of another accused. There are 4 accused in this case.
That is why I
Uh,
think.
they
Tape.
yes, they are moving bail separately.
Ah.
So in case
I forgot 376 DA is a gang rape.
Yes, Your
yes again.
DA. Okay.
Uh,
The advocates noticed that he has repaid and all. And after that, he filed he lodged his
Lordship, after October 2024, he stopped paying motion.
But then you admit that he
Yes,
paid
yes,
this 8 lakh
Yes, Lordship.
35.
Yes.
8 plus
Of the
35.
record. Lordship.
This is on the record.
Okay, and this 15 lakh is same 15 lakh, right? Not something else.
Yes, yes.
I'll
One time 15 lakh,
We-
another time.
No, Manal, we never used to mislead the
Same
court, Manal.
complainant.
We
Okay.
never used to mislead the court, Manal.
Because the FIR ballot, the FIR reflects 2523 Lordship. The FIR part Lordship.
Yes.
It relates to the incident of 2523. And that very day, Lordship, the declaration was executed on at the full court of
2523.
2523. Same amount, by the
Same
way.
15
Same
lakh.
amount.
No, that is all right. But then the advocate's notice speaks of
Yes. That there is
And
a
the
there is a-
condition is, Manal, that
Ah.
at 4%, if I delay,
I
that was the death, man.
Sir, I would have been penalized. I would have been penalized, Lordship, for interest part only.
okay, what I'll give is interim I'll give and then let the case diary be produced and
Yes.
seen later.
I will appeal.
Okay.
Will appeal.
But Mr.
Yes, again, no?
Yes.
Yeah.
A Saikya.
A Saikya.
Mr. A Saikya for the petitioner and Mr. D. Loi, the public prosecutor for the state of, the learned public prosecutor for the state of Arunachal Pradesh. Mr. The petitioner, while in the instant in the instant application has prayed for pre-arrest bail
Yes.
in pre-arrest bail in connection with Papu Hills Police Station case number 60 of 2025, registered under section 420/406 of the Indian Penal Code. Why IPC now?
Before BNS, Manal. Before BNS, Manal.
Oh, no, yes, but then this is 20
Cause of action arising on that, Manal.
cause of action
Yes,
was
yes, yes.
23.
Yes. That is going on.
This can be a
And
ground
over-
for your
over BNS.
pushing.
Yes.
This
Yes,
can be a ground.
yes.
Yeah, wrong registration. Okay. 406 of the IPC. Yeah, okay. Arising out of the first information report lodged by one Golom Gogi
Gobi, Manal.
on 23/5/2025. The prosecution story, the prosecution case in the instant petition is that the petitioner had taken a loan from the informant, an amount of rupees 15 lakhs, and executed a money agreement in the form of a declaration on 2/5/2023 in presence of the competent in presence of the witness, two witnesses. In presence of two witnesses, with a promise to return the said loan amount within 1 month. Full stop. It was also stated in the said declaration that if he fails to repay the amount within the said period, he would pay 4% interest per month in connection with the capital amount of rupees 15 lakhs. Full stop. The said form of declaration was notarized on the same day. The informant states in the FIR that he had loaned him on good faith so that he can improve his business. But he said that he was not repaid, he was not paid back his money by the applicant, and that he called him a number of times, but then the applicant blocked his number and he absconded. He as such lodged the Ejahar, FIR. Ejahar is stated over here or not?
Yes.
He lodged the Ejahar stating that he was lured and cheated by the applicant. The police, full stop, the police registered the said FIR under section 420/406. Where is the registration of the FIR? Ah, yes, I've got it. He registered the FIR under 420/406 of IPC on 23/5/2025. The counsel for the petitioner states and places a notice,
Reminder notice.
a
Reminder,
a reminder notice issued by the on behalf of the applicant to the informant, stating inter alia. Oh no, this is by the this is
By the
ulta hoga. By the informant
Gulam.
to the applicant,
Yes, ma'am.
stating inter alia that he had that although the applicant has repaid an amount of rupees 8,35,000, but then the applicant has to pay the remaining amount
Yes.
of rupees 16,85,000. The amount calculated by adding 4% interest per month. The it was also stated in the reminder that he should pay on or before 31st of December. No, before that, the reminder notice was dated 18/12/2024. Then you write, it was also stated in the reminder that he should pay on or before 31st of December 2024. Full stop. The counsel for the petitioner further states that the part of the money was repaid in the year 2024 itself. However, the informant, while lodging the Ejahar on lodging the Ejahar on 23/5, no?
23/5.
This is 23/5.
23/5 to 25. 23/5/2025.
23/5/2025, stated that he was not paid any of the loan amount. And that the applicant had absconded and has blocked his number and thereby cheated him. On the other hand, the learned public prosecutor for the state of Arunachal Pradesh states, what did you say about the fact of the case? That he should pay the remaining amount. Right.
Yes.
Okay. On the other hand, learned public prosecutor states fairly that the applicant has in fact paid part of the loan amount to the informant and that he should pay the remaining amount to the informant. Full stop. Para. Since it is seen from the documents annexed by the counsel for the petitioner that part of the loan amount was already paid, and without considering the same, the informant has lodged the ejahar stating nothing was paid, was not fair on the part of the informant. The money receipts were also annexed with the copy of the petition showing the amount paid by the applicant to the informant. No, there is something wrong. You see, page number 27, this money was given on 27 January 2023, before the agreement.
Yes, I have given something for, that is the personal.
No, that cannot be, because anything will be after. Okay, the rest of the money receipt is
Yes,
okay.
no, we are not counting that amount, madam. That's
No,
50,000.
see page 27 and 28, these are before the FIR, April and January. This cannot be in respect of the present FIR. What do you say?
No, madam, কোনটো আছিলে?
50,000 and the 5,000.
Because at that point of time, madam, we are having a very good relationship, madam. Those transactions are, we are not hiding anything, madam. Whatever we have paid, we have annexed, madam.
But if this cannot be in respect of that 50 lakhs, 15 lakhs.
Yes, that can be counted, madam, that risk, madam, the way 835, that is admitted fact, madam, by the informant, madam. That is admitted fact, madam. If we deduct 50,000, madam, if we count, madam, that would, madam, 835.
Is it?
Yes, can you count?
Just show me then. From the 50,000.
50,000.
Okay. Then 50,000.
Then 5,000.
lakh.
Yes.
Then 10,000. Oh, no. Then 40,000. 1,40,000. 1,50,000. 1,50,000. 2 lakhs.
40,000. 10,000.
2 lakhs. 3 lakhs.
50,000.
3 lakhs.
Table is given at page number 6, no, 6 and 7 also.
Page table is given.
Yes.
From that table also, no?
Oh, 6 and 7.
Yes.
Okay. But in January and February, you cannot count.
Yes, madam.
And rest.
Yes, we can count.
So it will not come to 8,49,000.
835,000. 835,000, not
Some
49,
amount
madam.
will be less.
Not 49, 835.
835.
Yes, 835.
835.
Yes.
And here this is 849.
Yes,
Not much.
not.
It is only.
Not much.
uh,
835.
Amount is not matched with the figure.
Ah. But whatever it is, okay. Then what did I say? From page number, you give, don't include April. From page number 29, Annexure 7. To page number 41, Annexure 19. Although it is seen that the amount given as alleged in the reminder notice do not totally match with the money receipt annexed with the petition. However, it can be deduced that payment by the applicant to the informant was made, and it cannot be said that nothing has been paid to the informant by the applicant pursuant to the loan taken by him during May 2023. As such, this court is inclined to give interim bail to enlarge the petitioner on interim bail upon furnishing of rupees 50,000. Upon furnishing a bail bond of rupees 50,000 with 2 local sureties.
Local surety?
He is a local person.
No, I am from
He moved
Karbi
to
Anglong.
Karbi Anglong.
Yes, madam. Karbi Anglong.
With 2 sureties.
Yes, madam.
One being government servant? No.
No,
One
it
being
is
government servant.
government servant will not come forward, madam.
There is allegation you have absconded. If you abscond again.
No. That is no, madam. No, madam.
With one government servant, right?
Both, madam.
One local surety.
Okay, one local surety. With two sureties, one to be a local
That is the part of the
inhabitant.
petition. Yes, that is the part of the petition.
One local inhabitant
Man.
of the state of Arunachal Pradesh.
Yes.
And what else? With the following conditions. To the satisfaction of the learned or of the investigating officer. With the following conditions. The petitioner would cooperate with the investigation and would appear before the investigating officer as and when called for.
Yes, madam.
He will not leave the jurisdiction of the number 2. He will not leave the jurisdiction of the he will not leave the local jurisdiction. He will not leave the jurisdiction of the local police station without informing the investigating officer, without the permission of the investigating officer. He would not tamper with the evidence and will not threaten or go near the witnesses of the instant case. And what else? He will cooperate, he will not go. He will submit his passport, visa, if any, to the investigating officer. He will give his statement to the investigating officer as and when called for. Okay. Call for the case diary. When can you bring?
No.
After 1 month, huh?
Yes, yes.
He's already on interim, so in between, he will statement vagera will be recorded. So call for the case diary and list the case on 23rd of July 2025.
May I add something, madam? Then madam, let the petition appear before the IO, madam, within 10 days, madam.
Okay.
So that he can produce all the documents, madam. Otherwise, madam, nothing will come along with the case, madam, because
Okay. The condition that I have given, he will, his statement, he will go and.
It takes around 15 days, madam. Kindly you lost it.
He will go and tender his statement before the investigating officer within a period of 15 days.
15 days, madam.
15 days,
15 days.
along with the documents, along with the required documents of the instant case. Okay? What else?
Lordship, may I submit, Lordship, there is a direction to not to leave the local jurisdiction of the,
Without the permission.
without that Lordship, Karbi Anglong, Lordship.
So with permission, he will go. But otherwise, we cannot just let him go to Karbi Anglong off and on.
Lordship, may I pray for modifying to the extent that he will not leave the jurisdiction of the,
And what?
he will not leave the place of his residence. I mean, the local resident.
Where does he stay?
He stays at Karbi Anglong, Lordship. He has to come all the way from Karbi Anglong and appear before.
He's a business person.
Yes.
He does his business here. He has to be here.
He never does business here, Lordship. He is a business, he does business over his in his locality only.
And declaration that manner, what we have next manner, that was executed in the Diffu manner. It is in the district of Diffu manner.
Transaction took place at Diffu. Declaration was executed at Diffu, Lordship.
This is our humble submission because manner, he is residing in Karbi Anglong manner. He will appear, we have paid manner, we may appear manner. Then after manner, we will produce each and every document manner. Let that investigation investigate into the matter manner. Then manner, I'll appear
We
manner.
changed the condition in this way, like he stated to be he will not leave his place of residence.
Yes.
Without the permission
Yes.
of the investigating officer, and he would report
Yes.
every week.
Yes.
He would report to the investigating officer every Saturday, every alternate or every Saturday, every week. That is on a Saturday. Every week he will report every week. That is on a Saturday to the investigating officer. He will have to come weekly. Yes, he will have to come weekly and report. So it will come up, let the matter be listed on 23rd July 2025.
Deeply obliged, madam. These are first time appear before the Lords.
Because these are all business transactions and you have shown that he has given some amount.
Yes, ma'am.
And 406, 420,
Yeah, not exact, madam.
hope he doesn't go away, let him report.
My appearance before your Lordship is first time, madam.
Oh, even me.
I'm deeply agree.
Thank
Wait, please, madam. Lordship, can you come to page number 12, the FIR? 12 is the FIR, and page number 15 is the written complaint of the informant.
I will, 1 second.
1-5.
1-5 is that is the format of the FIR.
Yes,
Then
page number 15 is the written complaint of the
15.
informant. Yes, 1-5.
Yes.
May I read, Lordship?
Chachi Lamam Langu, he is the, no.
No, there are 4 named accused.
Acha.
Number 1 is Srimati Chachi Lamam. Number
You are
2 is
Yani.
Yes, and the second one. Number 3 is Srimati Mabing, and number 4 is Mabing and Mabing. These 2 accused persons has already enlarged on bail.
Who were already enlarged?
3 and 4,
Three. Maiming and maybing.
maybe. Yes.
Okay.
Now, come to the content of the FIR. Yes.
Mm.
The undersigned wishes to lodge an FIR regarding a serious incident of physical assault causing grievous injuries, criminal intimidation, wrongful restraint, theft, and attempted murder that occurred on 23rd May of 2025 at around 3 to 4 p.m. at Gompa Road, Itanagar. On the same date and time, the accused person, namely Srimati such and such, number such and such,
Now, where are you?
and coming second, that is Srimati Yani Nablam Dada. Second,
Srimati Chachi. Then?
Chachi is the accused number.
Yani. You are Yani Nablam Dada.
And Miss Meming Nablam and Srimati Meming Lambu, along with 3 unidentified persons, making a total of 7 accused, in a pre-planned and coordinated manner, physically assaulted me using deadly weapons such as local-made knife and dao, thereby chopping off my right ear at Gompa Road, Itanagar. I was surrounded.
Chopping off my right ear.
I'm coming to that.
Mm.
See, I'll come to that. I was surrounded, threatened, and subject to physical harm without any provocation. The incident was witnessed by Miss such and such, who can corroborate the facts. After beating me mercilessly, they took my bag and mobile phone. The act has caused not only physical injuries to me, but also mental trauma. The nature of the attack, the number of individuals involved, and the coordination indicate a premeditated criminal act, punishable under the law of the land. I kindly requested to take cognizance of the matter and register an FIR against the accused person under relevant sections of law. This is it. So let's see. The story here is the informant. There is the informant and the husband of accused number 1. They were having an affair.
Informant baby Nablam.
Yes.
And husband of
accused
Thaki.
number, yes.
Ah.
They were having an affair since last 2024. So there was series of meetings between the family members to not to comply with all these things. So they agreed also. The informant also agreed, but secretly they were meeting. Secretly they were meeting. So on the fateful day, what happened also? The accused number 1 and along with 3 other ladies, they went some place to see a land, to purchase a land. And the vehicle was, vehicle so used was of my husband. The vehicle was of her husband. So she requested that her vehicle has taken away by her husband. That is the boyfriend of the informant, so-called. So we were coming after seeing the land, and we could see that the vehicle is at, actually the place is also wrong here. It's not Gompa.
Vehicle is your client's husband's.
Yes.
And relationship was between baby Nablam and husband of Chachi.
Yes.
Ah.
So she could see her inside the vehicle.
What?
She could see her near the vehicle, the informant. So what happened? She got angry. She got down from the vehicle and
Why did she get angry? What is the reason?
because informant was with her husband, even after having so
She
many.
saw.
Yes.
She saw the informant with her husband. Chachi saw.
Yes, Chachi.
But
And
then
the
you
fight
said
was-
all the 4 ladies had gone to see some land.
Yes,
Ah,
they were
then?
coming back.
Ah.
So when she saw her husband nearby the scooty, she recognized the scooty of the informant. So she got down and she started fighting with her.
Okay.
And they both got into a fight. The other 3 persons, they went to stop the fight.
Achha.
And in the fight, she bit her ear. Not chopping. She bit her ear and there was no weapons at all. That could
Who
be
beat her here, you said?
Chachi.
But otherwise here, who had beaten, who had chopped off her right here? What is the allegation?
Not specific.
Oh, not
Not
specific.
Yes. It was a fight between 2 ladies, the informant and the accused number 1. And Lordship, kindly see page number 19. I'm a lactating mother of 9 months old girl child. I am a lactating mother. I have a girl child of around 8.5 months child. And more so, the learned sessions got, I applied for the bail before learned sessions was also. The order is at Lordship, page number 16. And observation part is page number 17.
This
Last
is
line.
in respect of.
All the 4.
Okay, so.
So 2 got rejected. 2 got
maybe-
rejected.
Oh. Yani, it was rejected.
Yes.
Chachi also rejected.
Yes.
Only maiming was allowed.
Yes, maiming was because he was minor.
Oh, she
And
was
Mabing,
minor.
yes, Mabing was arrested last Friday.
13 years.
Mabing was arrested on last Friday
Mm.
at around 8 a.m. and she was released on bail at around 3 p.m.
Mm.
So here Lordship could see last line, in view of the above submission made by learned PP and considering that the nature of gravity offense and serious in nature, where a group of women attacked a victim with local knife and machete. So only on this ground, my bail was rejected. However, CCTV footage clearly shows there was no weapon at all. It was a sudden meeting of informant and the accused number one. That was not a premeditated.
But
My name is
cutting, chopping of the ear, it
Chop-
has to be by
it-
some weapon.
no Lordship. It would come on the CD. Some interim protection I need, Lordship. I'm a lactating mother, Lordship. Where will I go? I was there only to stop the fight. The other two accused also got bail, the named accused persons.
Chachi is not, this is AB,
No, no,
right?
yes, Lord.
Okay.
Chachi has applied for eligible bail in this very high court, which is fixed on 25th of this June.
Maiming and you said maiming is also allowed. Maiming, where is the order of maiming?
Maybe her order is not here because she was arrested on Friday and I filed it on Friday. That's why. She was again.
Otherwise, she
Yes.
is now on bail.
Yes.
She is not a minor.
No, she's not a minor.
The fact is that what you
Yes.
is saying.
Yes, Lordship.
And what do you say? Your additional PP?
Yes, my lord. Yes, my lord, the CD may be called for your lordship to ascertain the actual fact, your lordship, whether the weapon were involved or not. Otherwise, your lordship, considering what my humble submission would be, your lordship, since he's a lactating mother, that may be taken into consideration. Otherwise, your lordship, the allegation what has been made in the FIR, it's a general allegation against all of them. It doesn't say specifically that you were involved or you were involved. It's a general allegation. Just to ascertain their role, CD will be required, your lordship. Then your lordship may consider.
Okay. Since there are no specific allegation,
Yes, sir.
49 is there, I think.
No, Lordship. The only
149 is also not there.
No.
Common object vagera is not.
No,
there.
no.
126.
120 is a bailable offense and 118 that is grievous offense. Grievous.
Causing grievous.
118 is what?
118 subsection 2, my lord, the voluntary causing grievous injury
By a weapon,
by means
weapon.
or weapon.
By
Use of weapon.
Use of weapon.
61 2 is?
Common cause is not here. Common cause is not here in the FIR.
Wrongful restraint, I think. No,
Yes,
no,
only wrongful restraint.
Yes, your lordship, section. even-
126 is wrongful restraint.
Yes.
118, I think, is what?
Grievous.
Voluntary causing harm.
And 335 is also absent. Common intention is not there, ma'am.
Not there.
Yes.
What is 61 2?
61-2 is Lordship now
61 to
common cause.
Hmm?
That is now common cause. 61-2 is common cause.
61 2 is otherwise what? If you have-
61 to my lord.
But it is not in the FIR.
No, it's in the FIR.
No, Lordship, page number 12.
Huh.
Page number 12, kindly see serial number 2. Only 2 sections are inserted.
Sure. Bill number 2. 126 and 180.
Yes.
In the FIR, there is one more. 61 2.
In FIR 61 to is there.
61 2.
In the body of the complaint.
Conspiracy.
Conspiracy, yes. 61 to
Common cause.
Hey, it should have been rather common intention or
Yes.
common object. Why criminal conspiracy?
Yes, Your
It
Lordship.
was,
It should be 3-5, madam. Common intention.
D5, right?
Yes, yes.
So, okay. We'll give him interim bail and then pause for the
Yes, Your
question.
Lord.
But Mr.
Case Saxena.
And for the petitioner and K. Saxena, K. Saxena for the petitioner as well as Mr.
T at the, madam. T at the.
T.
T for token.
Ete.
Yes, madam.
Yes. T. Ete.
Yes, madam.
T. Ete, the additional public prosecutor for the state of Arunachal Pradesh. This instant petition is filed for PRS bail of the petitioner in connection with ITA Itanagar, I think,
Yes,
police
Itanagar.
station case number 88 of 2025,
Yes.
registered under section 126 within bracket 2 / 118 within bracket 2 of BNS 2023. The prosecution story, as stated in the FIR, dated 24/5/2025, is that on the same day, at around 3 to 4 p.m. at Gompa Road, Itanagar, 4 accused persons, one being the applicant, that is Srimati Yani Nablam Dada, the wife of E.R. Kacha Dada, along with 4 ladies, no? I said four accused persons, including one so-and-so, along with 3 unidentified persons, physically assaulted with deadly weapons, such as local-made knife and dao, machete. Surrounded, threatened, and chopped off the right ear of the informant without any provocation. The informant also stated in the said FIR that the incident was witnessed by one of her friends, and that after beating her mercilessly, they took her bag and mobile phone. The police registered the said Ejahar under section 61 within bracket 2/126 within bracket 2/118 within bracket 2 of the BNS 2023 and investigating the case. The counsel appearing for the petitioner states that there was a illicit relationship between the informant and husband of one of the accused, namely Srimati Chachi Nablam Lamgu, and the entire incident is in connection with the said fact. He stated that you have pleaded the same story.
Yes.
He stated and he has pleaded
Paragraph 7.
paragraph
7. Paragraph 7, last 3 lines, page number 5. The said fight was between Srimati Chachi Navlam Lambu and the complainant because her husband's affair with the complainant.
he has stated and has pleaded in paragraph, more specifically in paragraph 7 of his application, that the fight was in fact between accused, namely Chachi Nablam Lamgu, and the informant because of the said relationship. He also states that the FIR discloses that there were 7 accused persons involved in the incident. However, no specific act was attributed to any of the accused person in the said FIR. It was also not stated in the FIR who actually had chopped off the ear of the informant in the said incident. The counsel for the petitioner has also placed the bail granted by the Court of Session Judge, UPR Arunachal Pradesh, in respect of the other two accused persons. In respect of one.
One, naming.
In respect of one of the accused person,
Naming.
namely
Naming.
Meming,
Meming.
MEMING, Meming Nablam, NABLAM,
Other accused. Maybe.
What do you say that he had placed? Full stop. The instant applicant had also filed her bail application before the Court of Session Judge UPR. However, the learned court below rejected the bail application on the ground that the nature of the offense was serious where a group of women attacked the victim with weapons resulting in serious injury. Full stop. The learned counsel also has stated before this court that the applicant is a lactating mother of a child of a minor child, of a baby.
8.5 months.
Huh?
8.5 months.
Or of a child of 8.5 months.
Page number 19 and 20.
Where did I get the age here? Date of birth.
Page number 20 can be seen. The date of birth is 5/9/24 and the vaccination for 9 months is still pending.
Okay. On these grounds, full stop, on these grounds, the petitioner for the counsel for the petitioner has prayed for pre-arrest bail of the petitioner. On the other hand, the learned additional public prosecutor, Mr. T. Ete, states that although specific act in respect of all the accused persons are not mentioned, a specific act committed by the accused persons was not mentioned in the FIR. However, the incident is serious, which has resulted in grievous injury. Will it be a grievous injury? 420, I think 420.
Your Lordship, it's a grievous, 118(2) is a grievous.
The year.
Yes, Your Lordship. But Your Lordship, as per the FIR, it's a grievous one, Your Lordship. The section under which it has been recorded.
The section 420 is truth, breaking of truth and all this, no?
Yes.
Will it be a grievous injury?
Grievous hurt by weapon. Section 100 is very specific by weapon only.
Okay, you're right. Grievous, resulting in a serious injury.
Yes.
Of the informant. He, however, in his usual fairness has stated that the petitioner is a lactating mother and this court may consider the pre-arrest bail.
Yes, sir.
Heard the counsels for both the parties. Full stop. It is seen from the copy of the FIR, from the statements made in the FIR, that there are 7 accused persons, including the present petitioner, who had assaulted, who is alleged to have assaulted the informant and has caused serious injuries on her body. However, as has been submitted by the counsels, specific act was not attributed to any of the accused, much less the applicant, who had actually chopped the ear of the informant was also not stated. The ground of rejection by the learned sessions judge, by the learned session judge, that the offense is serious is not disputed. Full stop. The learned session judge had returned the finding that a group of women attacked the victim with local knife and machete. Is also borne by the records. However, who had assaulted whom? Who had actually assaulted the informant was also not borne out of the records. Further, the pleadings of the petitioner also brings forth the fact that the fight was actually between one of the accused and the fight was actually between one of the accused and the and the informant, and the other accused persons got involved in it. This court is not oblivious of the fact that the applicant is a lactating mother of a child of 7 months. Okay?
8.5.
Huh?
8.5.
8.5 months. Full stop. Since there was no specific charge against the applicant, and the allegations of assaulting the informant is in respect of all the accused, this court intends to enlarge the applicant on interim bail. Full stop. As such, the applicant may be released on interim bail upon furnishing a bond of ₹20,000 with one local surety of the like amount to the satisfaction of the investigating officer of Police Station Itanagar, Arunachal Pradesh. The bail is, however, subject to the following conditions. Again, the same conditions I'll put. Okay? The same conditions which was there on the other. Case diary, call for the case diary.
That will be on Monday again, Your Lordship.
Huh?
On 30, Monday.
Monday?
Yes, Your Lordship.
Call for the case this Monday.
Coming Monday, my lord. This is today.
He's already on interim bail, take 15 days.
Okay, Your Lordship. No issue.
So, or 1 month. Because conditions will be there.
Yes,
She will go
absolutely.
and give her statement and everything.
Yes, absolutely, ma'am.
After vacation.
Call for the case diary and then list the matter again.
22nd, my lord, then.
22nd of July 2025. Okay.
Oblige, Your Lordship.
Where to- Then-
May I please, madam?
Yes.
And by way of in this application, I'm challenging the NBW.
This is,
By way of this application, my lord, I'm challenging the NBWA issued on 27/5/2025
you have
by the.
appeared.
Not, I'm an officer, my lord, police officer. I'm presently serving at Dion Police Station, my lord. And in the year 2020, my lord, when I was transferred in a different district, there was I was the IO of one of the cases, my lord. That investigation has been culminated into charge sheet. And in that proceeding, I have been summoned to record my deposition, my lord.
Oh,
My lord, if my lord may allow me,
you were a witness. You are a witness.
as a police officer, my lord, I was the IO.
Okay, in the case.
Yes.
That is registered.
Yes, ma'am.
Okay, fine. There was no need. Had it been the accused person, okay, but then.
Yes, ma'am.
Now, where is the order sheet where you have not appeared in the
Page number
NPW?
13, page number 13, ma'am.
Oh, 30.
13, ma'am.
Oh, 13. You are Bobby Sumyam.
Sumyam. If I may read, ma'am.
Duly served upon the officer. He
First-
remained absent without intimation.
First paragraph, I admit, my lord, due to some family issues, my lord, I could not appear.
Let
Thereafter, my lord, there has been no willful disobedience on my part.
Acha, this 27/5 was the first day.
My lord, this is the date where the NBWA was issued, my lord.
And earlier, when did he not appear?
Appeared, my lord, down below, if my lord may peruse the order. Second paragraph, my lord. White order dated 29/1/2025, a fresh summon have been issued to the investigating officer through OC Police Station, Papu Hill, Naharlagan. However, report is awaited. That has been routed through a different district, but I have not received the summon. Now, down below, my lord.
26/3 also, BWA against investigating.
Yes, my lord.
So process was okay.
Yes, my lord.
Right.
There's no dispute.
Initially summoned,
My-
then BWA
Thereafter,
has already been issued. However, on 26/5, informed
Available-
the registry that he was on transit to 0 for deposing the evidence before this court today. He has informed the court staff over phone that he has not received any summon or warrant.
That has been misinterpreted, my lord.
Hmm.
In fact, the official exigencies which I was facing, my lord, I have informed the registry to convey the same to the learned trial court below.
Now, this language is little
Yes, my lord.
not very
That is
pleasant.
it. Yes, ma'am.
Because he has informed over phone that he has not received any summon or warrant. He would not appear.
On
So
that day,
something very unpleasant, but
otherwise, on that day, my lord, I was on the way. In the midst of my journey, my lord, I have received a telephonic call from a superior authority stating that I have to return back immediately since there was some law and order issue, my lord. Due to that official exigency, my lord, I had to return back. And that communication has been, I have made that communication to the registry,
it
my
was
lord.
not communicated.
Yes, my lord. That has been wrongly interpreted, my lord, which resulted in passing this NBWA.
The summons were not served upon him.
No, my lord. This
Because
bailable
it
warrant of
says-
arrest I have received, my lord. In compliance of the bailable warrant, my lord, I filed an application before the OC to appear before the learned trial court below. And that application, my lord, if my lord may peruse, page number 18, my lord.
Just this order, you see the last part, his conduct shows that he has knowledge of the matter on 30, 10, 29, 26, 27, of the case to be proactive.
Only once,
And then what you want to show?
if my lord may peruse kindly, page number 15, my lord.
Yes.
Page number 16 is a type copy, my lord.
Prayer for
Casually
casualty.
for one day to appear before the learned trial court below on the strength of receiving the bailable warrant of arrest, my lord.
Acha, he received warrant of arrest.
Yes, my lord. And accordingly, basing on this leave application, my lord, I have started my journey
Now,
for
let-
deposing,
let
my
the
lord,
court
the
be-
statement.
Session judge. He is the investigating officer of this 304A case.
Yes, ma'am.
Rash and negligent driving or what?
Yes, ma'am. He was the IO, in fact, initially, but later he has been transferred to the present place of posting. And in that investigation, my lord, that has been culminated into charge sheet. In that proceeding, my lord, he was summoned to record his deposition, my lord. There's no willful disobedience, only once, my lord. My lord,
Okay, you go and appear then I'll
My-
fix. When is the next date fixed in
next
this case?
date, my lord,
25/7.
my lord.
25/7 is
25.
July. So go and appear on 25/7. What do you have to say? Let him go ahead.
Yes, yes.
Heard Mr. uh-huh.
J. Sering, my lord.
They Sering,
My lord.
appearing for the petitioner. and Mr. You are D. Loi.
Yes, question.
Yes, D. Loi, Public Prosecutor for the state of Arunachal Pradesh. This instance application under section 528 of the BNSS is filed for setting aside and quashing of the non-bailable warrant of arrest issued on 27/5/2025 by the Learned Sessions Court 0. There is that order.
Order is at, my lord, page
Yes,
number 13.
yes, yes. The Learned Session Court has the Learned Session Court, while the said order, that is dated 27/5/2025, had issued non-bailable warrant of arrest upon the petitioner on grounds that initially, that is on 29/1/2025, summons were issued to the petitioner through the officer in charge of the concerned police station. However, there was no report of service of summons. The Learned Sessions Court also had held in the said order that thereafter, on 26th of March 2025, bailable warrant of arrest was issued against the applicant through their jurisdictional police station. And that thereafter, on 26th of May 2025, the applicant had informed the registry that he was on transit to 0 No, this transit to 0 means he appeared in the court, right? To appear in this court,
Well,
0 sessions.
0 sessions court. He was on the way, my lord.
No, just right. And thereafter, on 26/5/2025, the informant has informed the registry that he was on his way to the present learned court. The applicant thereafter informed the court staff over phone that he had not received any summon or warrant, and as such he could not appear in the court. The full stop. The applicant, however, without any disobedience, however, the applicant, without any glaring disobedience, had asked for issuing summons through the OC. The learned court below, despite issuance of summons, bailable warrant of arrest, what did I say? Just beginning of the line? The learned court. The learned court below. The learned court below, despite issuance of summons, had noticed that the applicant had not appeared on many dates, and as such, the learned court below was pleased to issue NBWA against the petitioner. Para. The counsel for the petitioner states that the petitioner has no has not committed any willful disobedience of the summons or of the BWA issued by the court. Due to his course of duties allotted to him, he was at times not at his residence, neither in his office. He as such did not receive the summons or the bailable warrant of arrest. The counsel submits that had the petitioner received any information about his deposition to be made before the court, he would have immediately rushed for the same. Para. The learned public prosecutor, look at that. In view of the submissions made above, and in the fact, and considering the fact that the petitioner is a witness in the case where his deposition was required and where he was called for, to depose, where he was called for by the learned trial court, comma, this court, and in view of the fact that he did not receive the notice, neither the bailable warrant of arrest, this court allows the petitioner to appear before the learned court of Sessions Judge 0 Sessions Division on 25/7/2025. That is the next date fixed in the present case. Full stop. If the petitioner fails to appear on the said date, relevant application may be filed
For cancellation or execution, Lordship.
for cancellation.
Cancel of NBW. Otherwise, the NBW will be enforced, Lordship.
I will keep that in abeyance. He will go.
Yes.
Okay. So in case what did I say? Date. No, not relevant. In said date, the authority is at liberty to issue non-bailable warrant of arrest. Or what did you say? Cancelling the?
Cancel the NBW or execute, Lordship.
No, mean to say recalling of the recalling application, my lord. Yes.
Recalling applications.
My lord, this
Issue.
NBW may be kept in abeyance and then I'll appear on the next date. And if if the petitioner does not appear, well, necessary orders can be passed as per the provision of law.
If fails to appear on that day, necessary actions may be taken. In the necessary actions can be taken for the ends of justice. till then, till 25/7/2025, the non-bailable warrant of arrest may be kept in abeyance. And the petitioner is directed to appear before the court without fail on the said date. That is on 25/7/2025.
25/7.
Okay, this petition is disposed of.
Right.
And you also write, the learned public prosecutor, before that, learned public prosecutor also does not object to the same after appearance. Okay, I'll see. This is disposed of. This application is disposed of.
May I please, my lord? Oh, my lord, the matter is today fixed for hearing on admission. It seems that private respondent, they are seeking time.
This is again some sitting MP/MLA
Yes,
case.
my lord. No, no, my lord. Not sitting and PM.
This was an
Or this is-
order by, under 145.
Yes.
restraining the-
Causing of the order 145 passed by Deputy Commissioner for Pakistan District.
Not to
But-
disturb the area of what?
Yes, status quo has been given.
Status quo.
Yes. In fact, my lord, this is civil nature of matter. The matter is related to the land disputes. So here in the case, private respondent, they have filed title suit before the learned court of civil justice senior divisions. And matter is pending before learned civil justice senior division SEPA. So because of this pending matter, so the matter is kept abeyance by the learned civil judge.
Here what had happened? You have asked for quashing of something?
Yes, my lord, causing on set aside of the impugn order, my lord, which was passed by Deputy
145.
Commission. Yes.
So you want some time? What?
The leading counsel, Mr. Jamu, is not here today due to the personal
You
difficulties.
the respondent.
Yes,
Private
private respondents.
You're for the private respondent.
Yes. the rest-
There are 1918.
Yes, my lord.
All their lands were
Yes.
were
My lord-
cleared or something. What had
Yes,
happened?
I have a plot of land, my lord. I have a plot of land since 1978, and I have also having LPC being issued by the ADC during 2010.
LPC is land?
Land possession certificate. So thereafter, in the 2016-17, the private respondent, they are complaining that I have encroached their plot of land. That is the case, my lord. So they have made complaint before Deputy Commissioner, and accordingly, Deputy Commissioner passed impugn order, my lord. Status quo matter. So now again they have filed title suit before the learned civil justice senior division. That matter is pending before. The
That is a
abeyance.
different issue. Here
Yes.
you cannot, here,
Yes.
because of this, that your title suit
Yes.
is being, there is a stay. It's not proceeding.
Yes.
Just, maybe fix after summer vacation.
Acha. This is otherwise seems to be an old matter, 2020.
Yes.
Yes.
And that title suit is also not proceeding at all.
Not proceeding, my lord. Because of the learned civil judge has said that the matter is pending before Honorable High Court. So the civil suit is pending with the cap abeyance, my lord.
Otherwise, there is a stay in that status quo, nothing. I don't
Yes.
think so. There is any stay here.
Yes, my lord. That's why, my lord, I have discussed with the private respondents, this order of Deputy Commissioner may be quashed. And then matter may be remand back to civil courts for decision of the title and portion, title rights and portions.
But then
The civil court is the right, correct jurisdiction to decide the title, my lord.
but then no way.
Yes.
Let
If
wait
they
for
are-
some time. As prayed for by Mr.
P. Padung. P. Padung.
P.
Padung.
Padung. P. Padung appearing for respondent number 2
Private respondent
19.
2 to 20.
2 to 20.
2 to 20.
Respondent number 2 to 20. List the matter on the ground as prayed for by so and so, that is senior.
Mr. Jamo. P. Jamo is
V. Jamo, that is senior. Mr. V. Jamo has some personal difficulty. List the matter after 2 weeks on a date to be fixed by the registry.
highly
And
obvious.
so
Much
and so
obliged.
are present, right?
Yes,
Mr. Rama.
N. Raman, yes, ma'am.
Mr. M. Rama is present for the petitions
Petition.
and Miss
T. Jini for respondent number 1.
Yeah, the government advocate.
Yes,
I'm the additional PP allowed.
Additional PP.
Yes. Since the matter was taken under 145 CRPC, Your Lordship, therefore I'm representing the Deputy Commissioner.
That can be done.
Yes, Your Lordship.
So and so for the Deputy Commissioner is as well as heard as a bill. Okay.
Much
Thank you. The petition. Domestic violence.
Yes, Your Lordship, the domestic violence proceeding under section 12 has been challenged under section 482, my lord. So earlier, Your Lordship, it was not maintainable as by the judgment of the High Court, but recently the Supreme Court held that it is maintainable, the 482.
Why 482 was not maintainable for quashing DV case?
Yes, Your Lordship, earlier, Your Lordship, there was various judgment from the other High Courts, Your Lordship, by the pool bench of the Madras High Court as well. But now, Your Lordship, the Supreme Court has clarified the aspect that this is maintainable now. That's it. The latest, the judgment is 2025 SCC online SC 1158.
Wait, give me the citation, 2000?
Yes, my lord, this is the copy, Your Lordship. Copy. 2025.
It is the prayer, actually, the petitioner side is not here.
Yes, other side is not there. Actually, Your Lordship, initially we raised objection on maintainability. Now that has been cleared by the Honorable Supreme Court judgment. So now we have to argue on the merit of this case.
It was after the dissolution of the marriage. The case was instituted after dissolution of the marriage.
No, my lord. It's
You are
not.
for the informant.
Yeah, I am for the respondent number 2.
The woman.
Yeah, it was.
No, what it seems is it is after dissolution of marriage, the DV Act was filed.
No, not dissolution of marriage. There was some kaba was there. But Your Honor, the annexure which relied by this petitioner, Your Honor, it is forged one, Your Honor. In my affidavit in opposition, I have made, Your Honor.
Oh, you have filed affidavit of opposition?
Yes, my lord.
It's not here anything. It's not here. Yes, it's here.
In my affidavit of opposition, paragraph 12, my lord.
But the petitioner side is not here. So
Yes,
we can
yes.
for some time or list it after a week or so.
Yes, listed after week. Yeah.
Okay. So none appears for the petitioner on call. Mr. T. Mr. T. Yes, Mr. T. the learned additional public prosecutor is present, and Miss
Jayadoji. Jayadoji.
Oh, you are the legal aid counsel.
Yes, I am legal aid counsel.
J. Doji for the respondent number 2. The legal aid counsel appearing for respondent number 2. List the matter.
My lord, after vacation. My lord.
After vacation.
Yes.
There are 2 weeks vacation here, right?
Yes, ma'am.
So list it after 2 weeks on a date to be fixed by the registry.
Yes.
This judgment I'm taking.
Yes,
no?
Your Lord.
Now. MSc appeal.
Yeah, my lord.
By the claimants or what?
Yes, my lord, I am from a claimant, appellant. So, my lord, basically ground is that the case was dismissed only want of proof of 279. The MSCT case was dismissed only on the want of proof of 279.
Or no ration negligent.
Or ration, but there is cogent evidence, which is there is a ZMFC report, copy of order, annexary. Whereas there is mentioned that the accident was taken place only on the negligence of the driver.
Okay.
So in such cases, there is no required to prove to just 279 by reasonable doubt. So that's the accident was taken place and the person was died. That's enough. The proof person was died on that accident.
And it is covered by insurance and all.
Actually, this is the government vehicle.
It's a government
vehicle, man.
Okay. What is the ground for dismissal? What is the ground? That is only that ration negligence
Yes.
having not proved.
So yes, that's down.
He died of drowning in water.
Yes, yeah.
Oh, because of natural conditions.
Natural, no, my lord. Actually,
Not negligence.
It was a rescue operation was carried on.
Oh.
That person was gone with the vehicle,
He was inside the vehicle.
inside the vehicle.
Acha.
And the vehicle was capsized in the Nala,
Okay.
and the person was that on there.
Because he did not see that part, I believe.
Yes.
There was water.
Yes, my lord. So as the person was that, and I'm the,
Admittedly, there is no negligence, rather.
Yes,
How
sir.
will you see the pit or whatever?
yes, my
If
lord.
it is covered with water.
My lord, even though it was not to 279, but the fact of the accident and due to that accident, the person was that. It is proved.
That will suffice.
Yes. Yes, ma'am. I have just annexed some, I have some mentioned some.
Do you have any judgment saying that even if there is no rash and negligence?
Yes, my lord, I have been mentioning page number 7, para number F.
Page number 7.
Yes, my lord. Para number F. National Insurance Company Limited versus Puspa Rana.
1 sec. 7. Paragraph?
Last paragraph
F.
F. The National Insurance Company Limited versus Puspa Rana 2008 CG 289. It was held that in case the petitioner files the certified copy of criminal records or the criminal records showing the completion of engagement by the police or the issuance of charges under section 279 to 304 or there is or certified copy of FIR or in addition of the recovery memo and mechanical inspection report of the offending vehicle. That documents are sufficient to prove to reach to the conclusion that the driver was negligent. There is not written, the search sheet is also required. Yes.
Charge sheet is filed.
No, charge sheet is not filed, Your Honor, because of this is the UT case. Case is registered under section 174 CRPC. So there is another rulings I have mentioned in page number 8. The Honorable High Court in the report case Godavari Devi Sharma and others versus United India Insurance Company Limited and others 2012 for GLT 516 held that. Moreover, while conducting the inquiry into a claim under section 166 of MB Act, the tribunal is not expected to search for proof of evidence beyond reasonable doubt. Rather, it is a preponderance of probability what the tool is for assessments of evidence. The tribunal can arrive at its findings on the prima facie materials, such as the first information reports to presume existence of certain facts, in absence of other evidence which might deviate such presumption. There is, it is an established principle of the law that in a claim petition under the Motor Vehicle Act, the standard of proof of established rash and negligent driving by the driver of the offending vehicle is not as per.
This is admitted, not beyond reasonable,
Yes.
but preponderance.
Yes.
But then some evidence for rash and negligent driving would require.
Yes, my lord, I have annexed a JMFC order, annexer E. Page number 18.
Page number?
18, my lord. Yes, my lord.
Plunged into the water canal, but
Yes, madam.
that overflew the road could
Yes.
not anticipate the condition of
Yes,
the
ma'am.
road.
Yes, ma'am.
Vehicle got
As a result, it fell into the depth of the water channel, resulting the death of the prisoner. That is, means there is a negligence of the driver. The driver ought to take some
driver
care.
is okay.
Yes, a driver is good. They also escaped from the vehicle.
But today is the first day, I think.
Yes, my lord. Yes, my lord.
Let the notice go. You are appearing for the insurance.
No, my lord, for the government,
Achha,
1 to
1 to 5.
1 to 5.
achha.
My lord.
Achha.
My lord, there is a 6 respondents.
Hmm.
1 to 5 is also appeared. So let me allow to issue notice to respondent number 6.
The driver.
Yes, madam. The driver
1
is
to 5 are represented.
and driver is also in his WS also admitted the fact.
That he got into
Yes,
that
yes, yes,
pit and whatever.
yes,
and
ma'am.
then- Okay. Right. But Mr. Baluram Das.
PR does, my lord.
PR Das. appearing for the appellant. Appellants, there are two appellants. They are the
Yes, my lord.
of the deceased, wife
Yes.
or somebody?
No, mother.
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 And what about petitioner number two?
He is the father, as he is.
Mother,
is-
father.
Yes, my lord. In a claim petition, they were made a party. It was necessary.
Heard Mrs. and Miss Devanga. Kesang. Yes. Kesang Wangmu. You're junior government? Yes, ma'am. Kesang Wangmu, junior government advocate. This is a full stop. Junior government advocate for the state of Arunachal Pradesh. This is an appeal filed against the filed against the order dated 8/4/2025 passed by the learned member of Motor Accident Claim Tribunal Teju, District Lohit, Arunachal Pradesh, by which the learned tribunal had dismissed the MSCT case number 4 of 2014,
15, my lord.
2015, mainly on the ground that
Want of proof of rash and negligent
Ah.
driving by the driver.
mainly on the ground that the accident was purely an act of nature without any negligence on the part of the driver. The learned court had held that there was no proof of rash and negligent driving on the part of the driver leading to the accident, wherein the deceased, namely Dimbeswar Nath, died because of drowning in the water. The counsel appearing for the petitioners, however, states before this honorable court that even in absence of evidence with regard to rash and negligent driving by the driver, the other materials on record that the deceased died out of the accident and what else you said? Died out of the accident and was a sufficient proof. You said that even
Yes,
without
yes. Even without the proof of rash and negligence.
No, that is, I said, even in absence of, what did I say? Even in absence of rash and negligent driving, the other materials on record that the deceased died out of the injury or died out of the accident is enough proof of the fact that it is a motor accident case and is liable for an award and is entitled for an award.
Yes.
You had placed two decisions now. What did you show from paragraph 7, right?
Yes, ma'am. Paragraph 7.
In order to substantiate his claim, he placed two decisions which National Insurance Company Limited versus Pushpa Rana,
Yes, my lord.
reported in 2009,
Yes.
ACJ, Accident Claim Journal,
Yes, my lord.
ACJ 2287, and Godavari Devi Sharma versus United India Insurance Company Limited, reported in 2012, Volume 4 GLT 516,
There is another, my lord, page number 9.
as well as Kaushnamma. Kaushmma. Kaushnamma Begum and others versus New India Assurance Company Limited. He has stated that in the said decisions, it was held that mere use or involvement of the motor vehicle in causing bodily injury or death to a human being or damage to property would make the petition maintainable under section 166 and 140 of the Motor Vehicles Act.
My lord, today is 140 is repealed. Changed, my lord, repealed. In place of 140, there is mentioned 164 in new MBA. So 166 can be mentioned.
It's okay. Motor Vehicle Act unamended.
Yes.
Within bracket, write unamended. Full stop, para. Issue notice. Oh, Miss Kesang Wangmu, Junior Government Advocate, appears for respondent number 124. 125. 125. 125. Full stop. Issue notice to respondent number 6 by registered post with AD. Returnable within 2 weeks. The petitioner to take steps within a period of 3 days from today.
Yes, sir.
List the matter after 3 weeks for admission hearing. This is also an MSc appeal.
Yes, my lord.
Same type of what? Oh, you're same concept.
Yes.
Yes. Same.
Same. Item number 13, 14, 15.
Ah.
They are the analogous case.
Hmm.
And the judgment is passed by the same court, Bomdilla.
But then different incident, different dispute
Different
and all that.
incidents, yes, my lord. Different incidents. In this case, my lord, the case was dismissed only that for the want of proof of 279. That is the Russell negative. Same. But yeah, my lord, in this case, the insurance company deposed their deposition before the honorable court, whereas they have admitted the fact that my vehicle is insured, the premium is taken, and the case is also liable to have a compensation. And the insurance policy, the premium for the vehicle and the premium for the persons also taken.
Oh.
Even though the court is dismissed only for the want of 279. That is taken from the MBI report. MBI report stated that the vehicle might be presumed to be failure of steering system. And the failure of steering system.
Okay.
Steering system. It was not confirmedly said in the MBI report. The MBI report in his report says that I am presumed. I have also mentioned in the petition. I am presumed it may be a presumption of steering failure. On that presumption, police submitted final report. And on that final report and want of 279, this case is dismissed. Okay.
So right in a similar way, heard Mr.
My lord, in this case, respondent number 1 and 2 is not required. It may be struck out.
Not required.
Not required. Because of vehicle is totally valid documents and the documents of the vehicle is not disputed.
So Bajaj Allianz and Ajit Das not required.
Bajaj not, my lord. Respondent number 1 and 2 is not required.
Yeah, respondent number 1 and 2 is Bajaj Allianz and Ajit Das.
Sorry. No, 2 and 3. 2 and 3, my lord. Sorry.
Okay. Ajit Das and Richum.
Yeah, fine. Owner and driver is not required.
Because they are not.
They are not private party, they are not required.
Okay. Heard Mr. D.R. Das for the petitioners. This is item 13.
13.
The petitioner. This case is filed against the order dated 28/5/2025,
Yes.
passed by the learned member of Motor Accident Claim Tribunal, Bomdila of District West Kameng, Arunachal Pradesh, by which the learned tribunal had dismissed the MSCT case number 10 of 2023 for want of proof of rash and negligent. Wait, 10 of 2023 on the ground.
For want of rash and
Ah.
negligence driving.
On the ground that there was no evidence to prove that there was rash and negligent driving by the driver, as well as on the ground that the final report and MBI report exhibited by the claimant
Yes.
as exhibit number 5 and 7 which showed that the accident occurred only because of steering failure of the offending vehicle.
Yes.
The learned counsel appearing for the petitioners, however, states that there are evidence on record to show the negligence on the part of the driver. Full stop. He had also stated that insurance is
Para number 5.
uh-huh.
Para number 5.
You said on both vehicle and persons? Para 5, okay. He also stated that the insurance premium with regard to the person, these are also technical terms, with regard to the personal as well as the vehicle.
Yes, madam.
The premium with regard to the person,
Yes, madam.
with regard to persons,
Yes, madam.
with regard to persons as well as with regard to the vehicle was paid. I think you have to amend the petition because everywhere you have written respondent number 3. Huh? Just see. Respondent number 3, otherwise you are construing as an insurance company.
Respondent number 1 is yes.
See paragraph number 5.
6.
And also 6.
Typical mistake.
Hmm?
Typical mistake. I think.
Typing mistake, but you have to correct it. Okay, I'll say that you correct it by hand and all.
Yes.
Whether that is allowed or you have to amend the petition.
That can be allowed, my lord, because of that there is only one numerical number is also that's mistake.
Or maybe there are in other places
No,
also.
no. There is only two paragraph 5 and 6.
That also in D, you see here, grounds of appeal in D. Respondent number is liable to pay compensation. Okay, you correct it by hand
Yes,
and
my
give
lord.
an initial
Okay.
by the side.
Okay.
And what did I say? For persons as well as the vehicle was paid. He stated that the insurance company has taken the liability through insurance policy exhibited as exhibit number D
Yes.
under section 147, 5 of the MV Act as required under section 147 within bracket 5 of the Motor Vehicles Act. Further, he submits that the MVI report is also not beyond reasonable proof that the accident has taken place due to mechanical failure. He as such challenges the order passed by the learned tribunal. Issue notice to respondent number 2 and 3 not required.
Not required. That may be mentioned in the order.
You have to file an application for amending the cause title. Okay.
For striking out the respondent number 2 and 3. My lord, it can be passed an order in orally.
No, actually not allowed, because nowadays even in pleading application, I'm told that we have to allow, then you have to file an application for amending the cause title.
Yes.
So you could withdraw it and file afresh without these mistakes, everything.
No, my lord, actually, after withdrawing to file and preface, again, I have to mention the respondent because of in the judgment that the opposite party is also mentioned. So it is necessary party, but
so then make them as performer respondent.
Then you are not record issue notice to all respondents.
Issue. Let's see who becomes
Yes.
liable to pay. Issue notice to all the respondents. That is from to respondent number 1, 2, and 3. By registered post with AD, returnable within 2 weeks. The petitioner to take steps within 3 days from today.
Yes. And same order may be passed in under two.
That is what the facts are a little different.
Facts are same. Analogous case, facts same judgments is passed on the same MBI report and same police.
Achha. Otherwise, accident is different.
No, same. Only when arising from the one incident.
So here 2 persons died. Oh, here
One vehicle.
Ah.
One vehicle. The person was in that vehicle. The accident.
Give me that file of the. And the rejection date is also same.
Same. Analogous case, my lord, same. Facts is same, just what is different. This person is different, claimant is different.
Same grounds you are taking that premium is paid.
Yes, same ground.
So then same order
Just
will follow.
MSCT case number may be changed.
Oh, MSCT case number will be different. So just right. MSCT case number
9/23.
9. MSCT case number 9 of 2023. Only that case will be different. Otherwise, same contentions, same rejected, same ground of rejection.
Yes, ma'am. Yes.
Same grounds of rejection. Check once. On rash and negligent driving and MVI report.
Yes,
right.
Yes, ma'am. Same ground. Because of The exhibits were same.
Acha, MBI report exhibited by claimant as exhibit number 5 and 7.
Yes, sir.
They're little different. Final report and MBI report, the place where you have written this, exhibited by claimant as exhibit number 5 and 7. That will differ. Okay, otherwise same. List after 3 weeks? List after both the matters, all the 3 matters.
All the same.
4. This is BA.
Bail. My lord. My lord, this one FIR.
Yes.
When I come to the phase 20 FIR now.
Why respondent number 2 and all? Who is respondent number 2?
Who is the informant?
Service is not complete here.
Your Lordship.
But whether it is required.
Your Lordship, it's not required as such, and only, I'll just brief Your Lordship that the trial is commencing, Your Lordship. Only 2 of the PW witnesses are to be examined, the doctor, Your Lordship. And they have come before this court that during the trial they are seeking for bail, Your Lordship.
What offense?
It's a murder and counseling during to commit offense.
Concealment of, yes. Achha. Murder?
Yes, my lord. Actually, my disease and the accused were in relationship. In relation.
The trial has
Commenced, my lord.
commenced and has reached quite far.
Yes, and there is no delay on the part of the court, Your Lordship. I would like to just place one judgment, Your Lordship, where the apex court states that once the trial commences, Your Lordship, the court should not interfere, Your Lordship. If I may refer to paragraph 14.
I'll come to you, but only that on the preliminary
Yes,
background.
yes.
Which one?
Paragraph 14, Your Lordship.
Yes.
It starts with ordinary and serious offense like rape, murder, dacoity, etc. Once the trial commences and the prosecution starts examining its witness, the court, be it the trial court or the high court, should be locked in entertaining the bail application of the accused.
Ordinarily in load.
Yes, then paragraph 16, Your Lordship. We are of the view that the aforesaid is not a correct practice that the court below should adopt. Once the trial commences, it should be allowed to reach to its final conclusion, which may either result in conviction of the accused or the acquittal of the accused. The moment the High Court exercises its discretion in favor of the accused and orders release of the accused on bail by looking into the deposition of the victim, it will have its own impact on the pending trial when it comes to practicing the oral evidence of the victim. It is only in the event if the trial gets undue delay and that too for no fault on the part of the accused, the court may be justified in ordering his release on bail on the ground that the right of the accused to have a speedy trial has been. In this case, Your Lordship, there is no fault on the trial, there is no delay on the trial, Your Lordship. The trial court has in a proper manner proceeded with the examination of the prosecution witnesses, Your Lordship. Only 2 of the, on 19, they might have, the last order, Your Lordship will see, I have plague marked in the TCR, Your Lordship. The prosecution witnesses of the 2 remaining witnesses were to be taken on 19th of this month, Your Lordship. Might have already been
Doctor
taken.
and the IO.
Yes, Your Lordship. If that is done, Your Lordship, the prosecution.
Doctor was not done. Who conducted the postmortem was not done. And another doctor is there, who certified that who given us their certificate, that was examined, and I was examined. And next that was posted on September, 4th of September for examination of doctor.
Doctor. Only examination of doctor is left.
Yeah.
Left, if that is the present status.
And for the PP, the court below trial court, they pray for the recalling of the some witnesses.
Recalling.
Yes.
311.
That they might file appropriate applications for recalling of the deaths. On 19, they verbally pray to the court below to recall the order. Then court observed that you file appropriate applications. So they might file an application also. So my lord, in my part, well,
Yes.
Here, informant is the brother of the deceased person. Then, when the incidents occurred, the accused himself brought the deceased person to the hospital. And
Where is the FIR?
FIR is at phase 20, 20, and type copy is at phase 21,
20.
21 is the type copy,
Okay.
Then,
Hmm.
after information report, it is to inform you that on 9/7/2024 at around 9:40 p.m. I received a call from relative from Zero informing that my sister Nako, 30 years, daughter of Nako Talin of Suluya, Zero, Lower Sunsu district, has been brought dead at Prince Nalagon. The emergency doctor has said that she was brought dead by Sri Kuru Halu, is the accused person.
He is the petitioner.
Yes, petitioner, accused, Halu of Sonapuru
To the hospital.
the hospital. There are numerous bruise marks on
This 304B or 302 is there, no?
302, yes, like 103, PNSS expert. Bruise mark found on the body of my sister, which indicate that she was brutally beaten till death by the accused, Sri Kuru Halu. Since the accused is currently in your custody, I request you to kindly register a case on charge of murder against Sri Kuru Halu so that justice provided to victim as well as her family members.
He is the husband of the deceased?
They were in relationship, actually not married. In relationship, they were. Then on that night, there was some scuffle between this accused and deceased. And next morning, they were whole night together. And next morning, accused went to the looking for maintenance of scooty. This is scooty. Next morning,
He went for?
looking for maintenance of his scooty.
Oh.
Then when he came back, he actually accused is working as a chokidar in the hospital. After attending the duty, when he came back to the rented house, he found that he was lying unconscious. So immediately he brought to the hospital, brought her to the hospital, and in hospital, doctor declared her is dead.
There are so many bruises and injuries.
Injuries mark is there, my lord. And my lord, as per the depositions of all the witnesses, my lord, there is no, my lord, chances for convicting the accused under 103, my lord, murder.
But then as she has placed the judgment, that will have an impact on the...
My lord, otherwise, to properly guide the counsel to properly defend himself, my lord. So otherwise, fact will be not properly, my lord, placed before the rounded trial court, my lord. Will not.
You must have moved bail before also?
Yes, my lord, 3 times. First bail was rejected on the ground that charge sheet has been filed. And again, we moved another bail application, and on that was rejected on the ground that there was a chances of hampering and tempering of the evidence. After the evidence, again I moved the bail applications. Then Land Court below rejected the bail application on the grounds that so far the deposit evidence is concerned, the conviction of the accused, chances of the conviction is there.
Oh.
So on that ground, they have rejected my third bail application, my lord. Now, my lord,
And now you are saying that there are no chances of...
hampering and tempering?
No chances of conviction based on the...
Yes, my lord.
But then the court held that there are chances of conviction seeing the evidences adduced before the court.
Yes, my lord. Well, accused is in custody for more than 11 months, my lord.
Oh, you have also annexed the deposition?
Yes, all the depositions, my lord. My lord, in fact, my lord, the deposition of the informant, my lord, can you see the deposition of the informant, my lord?
No, but then how to get rid of the judgment that she has placed?
No, my lord.
Huh?
Bail matter, my lord has the discretionary, my lord.
No,
Consider.
especially, okay, ordinarily it should not be.
Yes.
We can brush aside, say that yes, bail still can be granted. But
Yes.
then paragraph 16 that she has placed, that will have an impact upon the... And normally when the trial goes on without any delay and it goes on smoothly, then in that case, releasing someone on bail will have again some impact on the deposition of the...
No, my lord.
Right.
If
Get some judgments on your favor. Do you have?
no, I don't have, my lord. In fact, my lord, that judgment would be to prevent the absconding of the accused persons. Here, accused person is working as the chokidar in medical, and his father is working as a upper division clerk at 0 Lower Subdivision District, my lord. So
No,
even if the
see,
release,
no, those exceptions are not made. See paragraph 16, not a correct practice. See paragraph 16. Is not a correct practice that courts below should adopt. Once the trial commences, it should be allowed to reach its final conclusions, which may either result in conviction so and so. The moment the High Court exercises its power, an order release on bail, by looking into the deposition of the victim, it will have its own impact on the pending trial when it comes to appreciating the oral evidence. Here, of course, victim statement is not there, victim is dead.
victim is
It
dead.
is only in the event that if the trial gets unduly delayed, and that too, for no fault on the part of the accused, the court may be justified in ordering. If it is undue delay, then there is no fault on the part of the accused, then in that case, yes. Otherwise, now seeing the depositions.
Now my victim is not there, my lord.
Now, yes, that I have seen. Victim is not there. She is dead. This must be a rape case or whatever,
Yes.
FOXO case or. But then the fact remains, it's not
Let-
getting.
Text in respect of this cited by the learned PP, my lord, and facts in instance case would be different, my lord.
Bring some judgments on this favoring you. We'll take it up tomorrow, day after. Bring some judgment.
That's my
That still you can take up. This is by Supreme Court of India. This is in the year 2025. Very recent
Yes,
judgment.
recent, my lord. Still, my lord, it's originally, my lord.
No. There is no bar.
Yes,
That we know. But then this is not normal practice. This is what it is said. And that this is a murder case.
Yes, my lord.
And
Kindly see the conduct of the accused also, my lord. He brought the disease to the hospital and kindly see the deposition of PW1 informant, who is the brother who lodged the FIR, my lord. And the diseased body was handed over to the accused parents, and the whole funeral was done by the accused.
no,
parents.
on merit we should not go. Because on merit, if we give bail,
Yes.
then it will have an impact on the trial. Right? If we
No,
go
my
into
lord.
the merit of the case.
No, my lord. Now almost all the witnesses has been examined.
Now that is okay, but while during arguments and all, that will have an impact on the, if we go by merit of the case.
Otherwise, my lord, if I to proper guide my counsel on regarding the facts, my lord, if I not properly guide my counsel, my lord, injustice will.
You bring some judgments favoring you.
I'll try, man.
Tomorrow, day after, whenever you want.
Day after tomorrow, man.
Day after tomorrow.
I'll try, man.
In a pending case where there is no delay as such. Right. And during the verge of the conclusion of the trial. This is only the doctor is left.
Doctor, my defense part is there, man.
Huh?
Defense part, my lord, to defend himself.
Yes, defense part is there.
Yes.
And you said that recalling of
Is also
witnesses might also be there.
here, man.
But then these are okay. These are part of the proceeding.
Yes, man. Then, my lord, it's been 1 year, man, almost 1 year, my lord. So
You
next
bring a decision on that at the verge of the conclusion of the trial. Even then, bail can be allowed.
No.
Try
I'll try.
something, some High Court judgments.
No, I'll try, man. Problem.
The-
Yeah.
Oh, yes.
Yeah.
As prayed for by the counsel appearing for the petitioner, list the matter on day of 25th of June 2025.
Problem.
Rest of the matters are 2. I think we are rising at 3. There is a reference. We are rising. The courts are rising at 3. Justice Nandi will getting retired. So, and we have another one. Rest of the matters. Yes.
Marvelous, my lord.
Yes.
Due to changes of the today's circumstances, I am compelled to mention at this stage now, my lord. My lord, I beg to mention item number 27. This may be listed, yes, listed after 3 weeks, my lord.
Hearing matter, my lord.
My lord.
Could have done. After 3 weeks.
My lord.
Okay.
I am for the appellant.
Okay. As prayed for by Mr.
C. Modi.
C. Modi, appearing for the appellant, which is not objected to by the learned APP of the state of Arunachal Pradesh. List this matter after 3 weeks.
All right.
Obliged, madam.
Yes.
May I please, your lordship? My lord, my item is item number 1, your lordship.
1, 3 left.
Yes, your lordship. My lord, the thing is that, my lord, we prefer this revision petition against the order dated 28/4/2000.
You will do it now?
Yes, lordship.
Oh, okay. It was not called for, so I think.
Yes, lordship.
Okay.
I'm sorry if not to.
Not at all. Yes.
Lord, this revision petition is preferred before this honorable court against the order dated 28/4/2025 in connection with your lordship, sessions case number 45/2015. Lord, that this matter is pending before the district and session judge UPA.
Almost 10 years, see?
Yes, lordship. Almost 10 years has already been passed. However, my lord, at earlier point of time, my lord, the State Defense Council has conducted this case. My lord, we have gone through the records. As per the statements of the victim, as well as the independent witness in connection with this case, that is the PW2 and PW3, they have stated in 161 statement something different. And at the time of adducing their evidence examination in chief, they have stated some different things. And moreover,
not hostile, they were not declared.
no, your lordship. Moreover, your lordship, at the time of cross-examination, that contradiction part was not brought in the light before that honorable court. So, my lord, we pray before the honorable learned district and sessions as UPA to recall the seat PW2 and PW3 for re-examination of the seat victim as well as the independent.
But then she was examined, she was cross-examined, right?
Oh, yes, lordship.
Only that those contradictions were not brought.
Yes, lordship.
And she stated something different. Right?
Yes.
Mainly contradiction.
Mainly contradiction. However, my lord, at the accused person is just a 28 years old guy. So his life is at stake if we not cross-examination and do not brought on the record in the said cross-examination part. So at least, my lord, at least give us just one day to cross-examine, examine the PW2 and PW3.
3 it's only for justice. It's only for
yes.
of justice.
Yes, lordship.
But then change of counsels, you are saying that
initially
it was defense counsel.
Yes, lord.
State counsel.
Yes, madam. Earlier that was conducted by the State Defense Council. However, at that point of time, nobody was taken in his case. So no way left, he approached the state to engage some State Defense Council. So after that, when the matter, after 10, it's a long pending case. I also admit before this honorable court that. But the thing is that he go through some other engaged counsel, he finds that so many ambiguities and so many irregularities in connection with this case. And
change of counsels, you must be knowing, you are well aware.
Yes, I am aware of that.
It's not
speak about that. I'm not on that part, your lordship. I have preferred this petition on the grounds itself. I have stated, if your lordship go through my grounds, your lordship, at page number 8.
And what is the impugn order?
Impugn order is at page annexure 5, page number 31.
On what ground it was rejected?
It is the delay part, your lordship.
No, it was rejected on the part that the ground taken was that there is a new council.
No.
There was
a new council, appointment of new council.
I haven't, my lord, I haven't taken the ground that I'm the new council. That is why this the learned additional district and learned district and session just allow my petition under section 3.
Of that, your entire
no, your lordship. No, lordship. If your lordship go through the whole statement itself,
Your Lordship will find that. And moreover, whatever the grounds has stated by the learned district and session judge, I have a judgment. I'm relying on that judgment, Your Lordship. I will place that judgment.
First of all, let me see the facts and
Yes.
study contradictions.
Yes, yes.
If it goes to the root of the case,
Yes.
for the ends of justice, I might allow.
Your Lordship,
But let's see.
Yes, I have also an objection with regard to the maintainability. Your Lordship is well aware that any order passed under 311, Your Lordship, is an interlocutory order, Your Lordship. And therefore, since this is a revision, revision cannot be filed in an interlocutory order, Your Lordship.
But I think 311 will be intermediary order. Because it establishes rights on both the parties. Some rights are established.
Yes.
So in between interlocutory and final order, there is an intermediary order.
Yes, Your Lordship. However, Your Lordship will see that any order, because this does not decide on it does not culminate to the disposal or in any way.
Yes, not final order. It's not. But then some rights, because he wants recalling, re-examination.
Yes, Your Lordship.
And then it was not allowed. So
Yes.
in a way, it has affected rights of the parties. So
I absolutely agree to that, Your Lordship. I have certain citation, Your Lordship.
let me see. Because this is
Yes,
maintainability.
yes,
So
Lordship.
let me first take up this.
Yes,
one.
Lordship.
I'll just, I rely on paragraph number 4, Your Lordship. If I may read, Your Lordship.
Yes.
Secondly, what was not realized was that the order passed by the trial court refusing to call the documents and rejecting the application under section 311 CRPC were interlocutory order, and as such, the revision against those order was clearly barred under section 397(2) CRPC. The trial court in its common order has clearly mentioned that the check was admittedly signed by the respondent accused, and the only defense that was raised was that this signed check were lost and the appellant complainant had falsely used one such check. The trial court also recorded a finding that the documents were not necessary. This order not in any manner decides any finality. Therefore, both the orders, one on the application under section 91 CRPC for production of documents and other on the application of section 311 CRPC for recalling of the witnesses, were the order of interlocutory nature, in which case under section 397(2) revision was clearly not maintainable, Your Lordship. Even the recalling of the witnesses, Your Lordship.
But then again,
May I
it wasn't
submit to-
facts, because so many decisions Honorable Supreme Court has
Yes,
taken
even
up
in
against.
Madhulamya, Your Lordship, there is a, but then my contention is that,
Yeah, this was totally on interlocutory orders.
yes, yes,
But now things have changed. Now it has gone to intermediary orders.
yes, yes.
So
My only contention is that since it does not decide though it decide, because his right will be incurred only if he satisfies the court, Your Lordship. How is he prejudiced from it, Your Lordship? However, Your Lordship, will see that recalling of, there was a prayer for an application for recalling of the witnesses, Your Lordship. The order passed does not in any manner touch the finality of the case, Your Lordship, and therefore it becomes an interlocutory. It does not even come within the terms of intermediate order, Your Lordship.
anything on that, it will not even come within intermediate orders, because I was under the impression 311 one can challenge, because his rights were rejected. He was rejected throughout from calling.
But then his right also, the rejection of his right also did not incur, Your Lordship. He has to satisfy it in which manner. The only defense that was taken during the application was only on the sole ground of change of defense, change of the counsel, Your Lordship.
That is a different issue again.
Yes, Your Lordship.
As
So
far as
taking into
maintainability, you look into?
Yes, Your Lordship, maintainability, in connection with the maintainability, I have preferred it before this honorable court under section 401 of CRPC, Your Lordship. And right now for 48. Against the order, Your Lordship. I'm not prefer this petition for interlocutory application, my lord. This is an one application I submitted before the district and session judge court to recall the said witnesses.
No, see, 401 also
Yes.
of interlocutory orders.
Yes, Your Lordship, because at that point of time on 28/4/2025, my petition was rejected and I came before this honorable court on the said order. Whatever the order passed by the learned district and session judge, I came before challenging that order before this honorable court under section 401. If Your Lordship go through once 401.
No, 401, that bar is there, no interlocutory orders. So again, it comes within, if she is saying that this is an interlocutory order, then CRPC. But if it is it here? No. If it's an interlocutory order, then no revision lies.
But
See,
in the
401.
High Court's power of revision, in case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may in its discretion exercise any powers conferred on a court of appeal by section 386, 389, 390 and 391 or on a court of session or session by section 307, and when the judges composing the court of revision are equally divided in opinion, the case shall be disposed of in the manner provided by section 392. No order under this section shall be made to prejudice of the accused or other person unless he has had an opportunity of being heard either personally or by the pleader of his own defense. Nothing in this section shall be deemed to authorize a High Court to convert a finding of acquittal into one of conviction, where under this case an appeal lies and no appeal is brought, no proceeding by way of revision shall be entertained at the instance of the party who could have appealed. Where under this code an appeal lies, but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under the erroneous belief and that no appeal lies thereto, and that it is necessary in the interest of justice so to do. The High Court may treat the application for revision as petition of appeal and deal with the same accordingly. Moreover, I have preferred this petition under section 528 of BNSS, earlier 482. High Courts has the inherent power to.
No, that is 482 is different, or whatever the new section is.
Yes.
Now here you have come, let me see the cost title. Here you have come under 442 read with 528.
Yes.
So what is 442 BNSS?
It's corresponding to 401 only.
And 528?
482, Your Lordship. 482. Yes.
So he has used both revisional and inherent power.
Yes, Your Lordship.
Everything together.
Yes, that's it.
How can that be? Inherent power is for the ends of justice. For
But I have preferred this petition for the ends of justice.
Mm-hmm.
Because my prayer is that for the ends of justice, we pray before this honorable court to recall the same witnesses.
It's okay, you can pray under both, but not together. Either under 482 or 401, read with 397. But then one thing, 311, there are so many judgments.
Yes,
that,
I'm
right.
Yes, Your Lordship.
Supreme
But
Court
then-
has gone into lacuna, filling up the lacuna,
Yes,
and
yes,
those
Yes.
things are there.
Yes, Lordship. I am not filling up the lacuna, however, Your Lordship.
But let me look at the merits. Okay, I'll take care of the one thing
Yes.
you do give me some judgments on maintainability that this is not an interlocutory order. Because revision power, you have also taken the revisional power.
Yes, Lordship.
482 is there.
Yes. Inherent
Okay,
power.
let
This
us look into the merits now.
Yes.
Let me go through first the rejection order of the trial.
Yes,
On
yes,
what
yes.
ground?
At page number 31,
Okay.
Annexure 5, Your Lordship.
Hmm.
May I
Yes.
read? From operative part, can I?
Operative part.
From the page number 32.
Huh.
To substantiate the plea, learned counsel for the accused petitioner has relied on Rajendra Prasad versus Narcotics Cell, 6 SCC 110, and submitted that the Supreme Court held that even if a party closes its evidence, the court has the power to summon to witness if it is necessary for a just decision. Mistakes or lapses by either party should not prevent the court from finding the truth. Learned counsel has further relied Jahira Habibullah Sheikh versus State of Gujarat, so and so, known base bakery case. The Supreme Court has held that Section 311 gives wide power to the courts to ensure that justice is done. The aim is always to discover the truth, even if that means calling or recalling witnesses. It is prayed that PW 2 and 3, who are already examined and discharged after cross-examination, may be recalled and the defense may be provided. further opportunity for their cross-examination. I have carefully perused the records of the case and found that this is a case which is taken place during the year 2013, and trial of the case is pending before the court since 2015, and the case is pending for more than 10 years. It is also seen that PW2 and PW3 are examined on 3/3/2016 and 17/5/2018 before this court, and they are discharged after due cross-examination learned defense counsel. It is observed that engaging new counsel for defense can never be a ground for recalling witnesses who are already examined as PWs and discharged after cross-examination by the defense. Otherwise, there will be chaos in trial of the case. Honorable Rajasthan High Court in Chiranji Lal versus State of Rajasthan, so and so reputed as so and so.
Go to the next pages.
Yes, Lordship.
Have categorically hold.
Honorable.
Change of counsel.
Yes.
Cannot be exercised for valid reason, however, it is observed. File valid does not reveal any value. So no valid reason it is said.
Yes, yes.
Change of counsel will not do.
Yes, yes. Honorable Supreme Court in next page 33. Honorable Supreme Court in Jagdish Singh Keher versus State Shiv Kumar Yadav reported so and so have told that the power under Section 311 can be exercised only for valid reason. However, it is observed from the application under Section filed by the accused person does not reveal any valid reason. As the grounds taken in the application under Section 311 CRPC are not considerable for recalling witnesses for the re-examination, accordingly, Ms. Case so and so stands rejected. Now I want to bring the light of this honorable court at page number 16, Your Lordship. That statement of the victim before the police, Itanagar police, Your Lordship.
So 167.
Ma
Page number 17.
Yeah, no, my lord, 16.
Okay. This is the case under what?
Section 307 and 326, Your Lordship.
Okay. Attempted murder and
Yes,
grievous.
attempted murder, grievous, sir.
Okay.
On 12/3/2013 evening, I, along with my two other friends.
Wait, bear 16.
Yes.
Oh, I'm a
Hello.
student. So he is she or he?
He, Your Lordship.
He is the victim.
Yes. Along
He
with,
was assaulted.
yes, he was assaulted.
Read the first paragraph also. I'm a student.
Oh, sorry.
Stay with my parents.
I am on being asked the police. I am to state as follows that I am a student and stay with my parents at Niti Vihar, Itanagar. Since we belongs to a big family and my elder brother is pursuing engineering degree, so I decided to run a shop to bear my.
Here, look at the spelling.
Yes, ma'am.
To bear my
academic expenditure. Sri Rahim Ali is the manager of business of a businessman, and he has good knowledge of business, so I decided to invite him to discuss the same matter. On 12/3/2013 evening, I, along with my two other friends, Sri Rahim Ali, gathered at Sanke View Tiniali, where my father has 3-4 shops in which I was planning to open a shop in a room. All of them suggested their own view, and finally we decided that a Xerox machine shop will be profitable at that place. Since in that night there was hot weather, so we came out from the shop and were sitting in Sanke View Tiniali. But at around 11:30 p.m., one local boy who later identified that Longfu Take reached to the spot and started argue that why we were sitting at late night, and when I replied that my residence is just behind the shop, that person got angry and started quarreling with us. Since it was late night, so we decided to get dispersed from that place. Subsequently, after half an hour, my two friends went to their home, and I, along with Rahim Ali, left the place, left for my residence. But the same person again arrived in Yamaha R15 bike, white color, having armed with a dao, and challenged us. Since he was a very violent, so we ran away towards my residence. But the said miscreant started chasing in his bike and ultimately attacked with a dao on my neck in front of my residence on the roadside, which I protected with my left hand. But he again attacked on my face, and I have saved this time with right hand. Since Sri Rahim Ali was shooting my parents, so the miscreant fled away from the spot in his bike. After the said injury, I got unconscious and fallen and in my campus while proceeding to my residence. I can identify Sri Longfu Take after seeing his photograph maintained at PS as culprit who attacked on my face on so and so night. Now, Your Lordship, kindly.
For Longfu Take.
Longfu Take, Your Lordship, the accused person.
Then what is the statement?
Statement before the district and session judge at page number 24.
Was he examined under 164? No.
No, Your Lordship.
Then,
On 12/3, may I read, Your Lordship? On oath, on 12/3/2013, I along with my friend Rahim Ali were working inside one vacant room to open a top-up shop at Niti Vihar, Itanagar. While we were working inside, some boys aged about 14-15 years came and knocked the door asking for some cigarettes, beer, etc. I replied that we were still preparing to one shop and we have not kept anything yet and send them back. After some time again, those boys came, knocked the door, asking for the same thing. Then I came out from the room and again told them the same, that the shop is not yet open, and scolded them why they should come time and again disturbing us. After some time, accused also came there and knocked the door, asking some things. There was a smell of alcohol in him at that time. I told him also that the shop is not yet open and we don't have anything to sell. So he left the place. After about half an hour, we also closed the shop and were going back to our residence, which is nearby the shop. The distance between my residence and the shop is 50 meters. While we were still on the way to our home near our gate, suddenly the accused standing on dock came in R15 Virgin to Yamaha, stopped near me and straightaway attacked me with dao from the back, first on my left hand, and then I turned towards him, and by that time accused hit me with a dao on my right hand, accusing grievous cut injuries on my both hands. My Lord, may I draw the attention of this honorable court? This earlier part, whatever this guy, the victim stated before the examination in chief, he did not state it before the police.
It's a different.
Yes, Your Lordship, totally different. Moreover, Your Lordship, if Your Lordship go through the medical officer, he stated that at the time of examination, he was under the influence of alcohol. So, my Lord, there are so many ambiguities and irregularities at the time of examination in chief and before the police. Whatever he
These
stated.
things will not be very relevant because before police, he said we came out, we were with other persons, and
Yes.
then we were sitting.
Yes.
They came and
Yes. Yes.
and here he said he was inside the shop.
Yes.
And then they came, knocked.
Yes.
And then he said it's shop is not open, don't ask
Yes.
me anything.
Yes. Yes. Yes.
So very
However-
difference, but then not to the
However-
root of the case.
Yes. However,
Root of the case is that he was assaulted.
yes, I understand, Your Lordship. Lordship is correct. But the thing is that, my Lord, at the time of cross-examination of the said victim, if Your Lordship go to the cross-examination part, kindly go through once the cross-examination part at 25 and last paragraph.
Acha.
I did not recognize the accused prior to the incident. It is not a fact that the accused standing on the dock is not the
I did not
person.
recognize the prior. Okay, it is not affected. Accused standing is not the person.
In injury on both hands. I cannot say why he assaulted me with dao. It is not a fact that at that time I was also indulged in some illegal activities, some sense. It just 2 paragraphs. My Lord, at least give us a fair opportunity to cross-examine this guy, because at the time of 161 statement, he stated some different thing. And before the examination in chief, the whole story has changed from one end to another end.
No, whole story has not changed, only that first part. Right.
At least, my Lord, at least give us an opportunity to bring on the light of the said things before. Just one date may be allowed us, that on that particular day we are going to cross-examination in the PW2 as well as the PW3, who is the victim as well as the independent witness is concerned, my Lord. And moreover, we are ready to bear the cost even, Your Lordship. Lord, at least that may be granted before this honorable court for the ends of justice. And whatever the district and session judge dismissing my petition on being pending for 10 years, I'm going to rely on judgment of the Supreme Court.
Change of counsel, there is a decision, I think. Even
Yes,
change
yes,
of
yes,
counsel,
yes.
Even change of counsel, it may be allowed.
Yes.
There is one decision. I
Yes.
was also a public prosecutor, so
Yes.
I had gone through that once.
Yes, yes.
But the merits are not in your favor. Because see, again, let us see again.
Yes.
So you are only on contradiction.
Yes.
So he said in his statement before the police,
Yes.
I along with my 2 friends and Rahim Ali
Yes.
gathered at so-and-so where my father had shops.
Yes.
in which I was planning to open a shop.
Yes.
All of them suggested their own view, and finally we decided a Xerox machine is profitable.
Yes, Lord.
Since in that night there was hot weather, so we came out of the shop
Yes, yes,
and were sitting in Tini Alley.
yes.
But that around 11:30, one local boy who later identified so-and-so reached to that spot and started arguing and why we were sitting.
Yes.
I replied, residence is so-and-so. That person got angry, started quarreling. Since it was late, we decided to disperse. Subsequently, after half an hour, my two friends went. I, along with Rahim Ali, went. But the same person again arrived, having armed. Since he was very violent, we ran away. But then sir chased in his bike, attacked with a dao, protected with my left hand.
Yes, Lord.
Then he shouted, and my parents came out.
Yes.
Now, here what he said, he was inside the shop.
Yes.
Working inside, some boys came, knocked the door.
Yes.
With cigarettes, asked for some cigarettes.
Yes.
We were preparing to open. We
Yes.
were not, and knocked the door again. Then I came out and
Yes.
told that shop is not open.
Yes, Lord.
At the same time, they knocked.
Yes.
There was a smell of alcohol. I told him shop is not open.
Yes.
Again, there was of course, the story
Even
is
then-
little different. But
Yes,
then,
even then, my lord.
but whether by bringing that contradiction, you can say that this witness is not believable.
Yes, Lordship.
That is what your
Yes, my
Yes.
argument is that, my lord, if this honorable court allow us to cross-examination, there are so many things in this case. However, I could not disclose it before this honorable, so my lord, my respectful submission is that at least give us one date, just one date. On that particular day, both the two victim and the independent witness, we are going to cross-examine.
And what is other evidence after you had stopped in both hands?
Yes.
After assaulting me, they fled.
Yeah.
Fell on the ground unconscious. To the extent I regained my consciousness. Treatment is going on.
Yes. It took
I
completely
never
1
knew
year
the
treatment.
accused.
Yes.
Prior to the evening.
Yes.
I met him only that night.
That
He came
night
to
when
my
he
shop.
came
I
to my
was still
shop,
in the
while I
police
was still in the hospital, the
We
police
were
sent
very close
some
by.
photograph to identify the accused.
My life has become miserable. While I was in treatment in Coimbatore. Okay, this is your argument.
Yes, and moreover, your lordship, I am relying on judgment regarding whatever the learned district and session judge dismissed my petition on regards to page number 32 on paragraph number 2. I have carefully perused the records of the case and found that this is a case which is taken place during the year 2013, and trial of the case is pending before this court since the year 2015, and the case is pending more than 10 years. On the basis of this ground, the learned district and session judge dismissed my petition. However, I am relying on judgment, your lordship.
Yes. Sanjeeva Rao. Which paragraph?
At operative portion is at paragraph 14, your lordship. May I read, your lordship?
Yes, the scope and power.
The yes. The scope of power of the court to recall witnesses was examined by the court in Mohanlal so and so. The principle of law that emerges from the views expressed by this court in the above decisions is that the criminal court has ample power to summon any person as a witness or recall and re-examine any such person even if the evidence on both sides is closed, and the jurisdiction of the court must obviously be dictated by exigency of the situation, and fair play and good sense appear to be the only safe guides, and that only the requirements of justice command an examination of any person which should depend on the facts and circumstances of the case. And this is supplied. Discovery of the truth is the essential purpose of any trial or inquiry. Observe 3 judges' bench of the Honorable Court in Maria Marquerida Siqueira Fernandez versus Erasmo Jack de Siqueira through LR 2013 Clause 3 scale. A timely reminder of that solemn duty was given in the following words. What people expect is that the court should discharge its obligation to find out where in fact the truth lies. Right from inception of the judicial system, it has been accepted that discovery, vindication, and establishment of truth are the main purposes underlying the existence of the courts of justice. We are conscious of the fact that recall of witnesses is being directed nearly 4 years after they were examined in chief about an incident that is nearly 7 years old. Delay takes a heavy toll on human memory, apart from breeding cynicism about the efficacy of the judicial system to decide cases within a reasonably foreseeable time period. To that extent, the apprehension expressed by Mr. Rawal that the prosecution may suffer prejudice on account of a belated recall may not be wholly without any basis. Having said that, we are of the opinion that on a parity of reasoning and looking to the consequences of denial of opportunity to re-examine of the witnesses, we would prefer to err in favor of the appellant getting an opportunity rather than protecting the prosecution against a possible prejudice at his cost. Fairness, the trial is a virtue that is a sacrosanct in our judicial system, and no price too heavy to protect that virtue. A possible prejudice to prosecution is not even a price, leave alone one that would justify denial of a fair opportunity to the accused to defend himself. In the result, we allow these appeals, set aside the orders passed by the trial court as also the High Court, and direct the prosecution witness number 1 and 2 shall be recalled by the trial court, an opportunity to cross-examine the said witnesses afforded to the appellant. In fairness of the counsel of the appellant, we must record that he assured us that given an opportunity to examine the witnesses, the needful shall be done on 2 dates of hearing on each of each witnesses, without causing any unnecessary delay or procrastination. The trial court shall endeavor to conclude the examination of the 2 witnesses expeditiously without unnecessary delay. The parties shall appear before the trial court on so and so, Your Lordship. Moreover, Your Lordship, I am also relying on judgment. My Lord, in this paragraph number 10, Your Lordship, the object of section 311 is to bring on record evidence not only from the point of view of the accused and the prosecution, but also from the point of view of the orderly society. If a witness called by the court gives evidence against the complainant, he should be allowed an opportunity to cross-examine. The right to cross-examine and a witness who is called by a court arises not under the provisions of section 311, but under the Evidence Act, which gives a party the right to cross-examine a witness who is not his own witness. Since a witness summoned by the court could not be termed a witness of any particular party, the court should give the right of cross-examination to the complainant. These aspects were highlighted in Jamtaras Kawali Govani versus State of Maharashtra so and so. The above position was highlighted Jahira Hazibullah Sheikh and another versus State of Gujarat so and so.
Court witness.
Yes, Lordship. In the background of the facts, the case, we are of the view that trial court ought to have permitted the prayer of the appellant. That being so, the rejection of the prayer by trial court was not proper, and the High Court should not have declined to interfere. The appeal is allowed. The trial court shall fix a date within 3 months and call the witnesses in question, accord opportunity to accused person, and thereafter proceed with the trial. Moreover, my Lord, we are ready to bear the cost even, my Lord. At least give us an opportunity to re-examine the said 2 witnesses, at least for the ends of justice. I am not on the part of changing of the advocate. However, at that point of time, some State Defense Counsel was conducted this case. And moreover, if Your Lordship go through the cross-examination part, there are just 2 lines there. However, so many allegations are there. The State Defense Counsel did not bring the light of the facts of this case. So, my Lord, at least give a fair opportunity for the ends of justice to the accused person in connection with this case by allowing the...
He is the only eyewitness in the case.
Yes.
Or that Rahim Ali is there.
Yes, Rahim Ali is there. However, 2 witnesses, whatever the statement of the said victim, there are 2 more friends who were there. However, the police did not make them a party. That who are the 2 guys at that point of time?
They did not find out.
They did not find out.
Only Rahim Ali and he.
Rahim Ali and the victim.
Eyewitness.
Yes. And moreover, Your Lordship, the medical officer stated that he was under the influence of alcohol. There might be some fight also. So, my Lord, at least, my Lord, kindly give us an opportunity with a...
Who was under the influence of alcohol?
My Lord, that the victim, Your Lordship.
Victim himself.
Yes. The statement is there, Your Lordship.
To a certain extent, you can say like, yes, if his statement differs.
Yes.
His story, his initial story differs.
Yes, Lordship.
Although later on he was attacked and all he came in the same vehicle. He has named the vehicle also properly in both the statements.
However,
So
Your
he
Lordship.
came, but then yes, both the story is little different.
Yes.
If the witness can be arrayed as partly believable,
Yes, Lordship.
that judgment,
Yes, Lordship.
wholly unbelievable, partly believable, then his statement will go. But then Hanif Ali's statements will remain.
Rahim Ali's statement.
Rahim Ali's statement will
Yes,
remain.
yes, yes.
Why I'm going into that, whether justice will be done.
Yes. I'm.
If this one goes, Rahim Ali, then the sole eyewitness, then again that point will be taken care of.
Yes, Lordship.
Okay, I'll look into then what is that is all.
Yes, my respectful submission before this honorable court is
But
that.
I'll have to go through. I have to go. Today I'm not passing the judgment in the chamber, I will pass.
Yes, Lord.
Mostly on the fact whether it's an interlocutory or intermediary. If it is interlocutory, of course, 482 is there, right?
Yes, Lordship.
Inherent power.
Yes, inherent powers of this court is there, Your Lordship.
Okay, but Ms. Ginny.
Yes, Your Lordship, Your Lordship will look into the maintainability, Your Lordship. Otherwise also, Your Lordship, the submission being made with regard to the contradictory that he's pointing out at present, Your Lordship, was that a ground on the application for recalling, Your Lordship, before the trial court, Your Lordship? Your Lordship will, for a second, come to page number 31, Your Lordship. What were the grounds taken, Your Lordship? If I may read from the third paragraph, Your Lordship.
Yes.
Seen criminal miscase number 127 of 25 filed by the accused person under section 311 of CRPC, praying for recalling of the witnesses who has examined as PW2s and 3 in the present case. It is submitted by the learned counsel for the petitioner that in present case there is contradictory statement deposed by the witnesses which were not in the 161 statement of the witnesses record by the police. That is one of the ground, Your Lordship. The second is it is submitted by the learned counsel. Earlier the case was tried by state defense counsel for accused person and learned counsel Mr. So-and-so is newly engaged in the present case. It is submitted that PW2 and 3 may be recalled for their examination as provided. Now these two were the only ground, Your Lordship. On the first ground, Your Lordship will see that where the contradictories were brought to the knowledge of the honorable trial court, Your Lordship. The trial court has very clearly in his impugn order stated that the ground that has been prayed for was not a valid ground for recalling of the evidence. And the second was that the changing of a new counsel cannot be ground, Your Lordship. The third was that though matter was pending for 10 years, Your Lordship, already the examination of PW2 was done in the year 2016, PW3 was done in the year 2018, Your Lordship. Even after a lapse of more than when the examination were done, there was never an approach made with regard to recalling of the witnesses, Your Lordship. Now, Your Lordship has rightly pointed out that Supreme Court on many occasions has stated that changing of the counsel cannot be a ground for certain facts. If during the before the trial court, if genuine grounds would have been taken, the validity of the grounds that could have been taken, if that was to be considered, recalling could have been done, Your Lordship. However, the placement, Your Lordship, I'll just rely on a judgment, Your Lordship, very short judgment.
You spoke of only one witness and you want to recall 2 witnesses. So who is the other one?
Rahim Ali, Your Lordship.
Oh, Rahim Ali also?
Yes.
No.
2 witnesses.
PW2 and 3, Your Lordship.
PW3.
PW2
is the victim.
PW2
PW3 is the independent witness.
So what is the wrong with Rahim Ali's statement? Why you want to recall him?
Because whatever the statement of the victim, same was there.
Same differences.
Yes, Lordship.
Show me that.
At page number 18, Your Lordship.
Page number 18.
Yes, Lordship.
18
161 statement.
161.
18 is Rahim Ali's 161.
Yes, Lordship.
Okay, what is the difference?
I am
That I know. Yes, that I know.
I am as above on being so and so that I am the manager of Srimati Toko Shital near C2 sector petrol pump Itanagar.
Toko Shital is the other one's father's company.
No, Your Lordship. He was an independent person who worked as a manager in a petrol pump, Your Lordship. However, there is a friendship between the Rahim Ali and the said victim. Right.
No. The victim said, I think victim statement was where?
Victim said.
Page 16.
Yes, Lordship.
He said Rahim Ali is the manager of a. we belong to my elder brother is, I decided to run a shop. Sri Rahim Ali is the manager of a business and has good knowledge of, oh, acha, acha. He is of a different, okay then, right. Read, page 18.
Yes, that I know Sri Tai Chanam since last 1 year, who is resident of Niti Vihar, as his parents have good relation with my owner. Nowadays, we are a good friend and share the entire problem with us as friends, as a friend. On so and so, Sri Tai Chanam invited me to come near at Niti Vihar to discuss about a business which he wants to run at Niti Vihar Sanki View Tiniali. Accordingly, as per schedule time, I reached to the Sanki View Tiniali at around 9 p.m., where he, along with his two other friends, Thai boys, were already present. We were sitting in the shop. Sri Tai Shanam told me that he wants to run Xerox machine shop in the said shop to bear his personal expenditure.
Of Tiniali. He
Yes.
went to Tiniali, not
Yes.
the shop.
Yes. After that, we came out from the shop due to hot weather and were sitting near Sanke View, Tiniali. But at around so and so, a person reached to the spot in bike and started argue that why we are sitting at late night. And when Taishanam replied him that his residence is just 20-30 meters far from the place, the person got angry and started quarreling with us. Since it was late night, so we decided to get dispersed from that place. Subsequently, after half an hour, both the Thai boys returned to their home, and I left with Sri Tai Shanam for his residence on his request. But surprisingly, the same person again arrived in the same Yamaha R15 bike, white color, having armed with a dao and challenged us. Since the said person was very violent, so we ran away towards his residence, but the said miscreant started attack with dao, due to which Tai Sanam sustained injuries. However, anyhow, I rushed to the residence and informed his parents about the incident, who immediately came out from their residence and found that Sri Tai Chanam was lying in the campus in unconscious condition due to excess bleeding, as his both hand was chopped, and the said miscreant fled away from the spot.
Same like Taichanam.
Yes.
Statement. And what is his statement?
What is his statement at page number, Your Lordship?
27.
27. On oath, I can identify the accused Langpu Take, who is absent today, so and so. At about 9 p.m., I was called by Tai Chanam to repair his shop, Sanke View. Linearly, as view of us repairing his shop, some boys came asking for Tironga and others, on which he said that he did not have the same. Then the accused in a bike came and started asking for Tironga and Tamul. On being denied to give
This
the...
Tiranga is some cigarette.
Yeah, no, my lord, gutka.
Oh, acha.
Chewing. The accused person started argument with us. After a while, the accused went back and again appeared with a dao along with him. From the back of the dao, he hit me once on my back. Thereafter, I fled from there. The accused chased me with his bike. In my presence, the accused inflicted cut injury on Tai Chanam both hands with his dao just in front of Tai Chanam's house. After inflicting the injury, the accused fled away in his bike. I went inside the house and informed the mother of Tai Chanam. Later, in the vehicle of his mother, Tai Chanam was taken to RK Mission for treatment by so-and-so. That cross-examination part is, initially there was 2 more boys working in the said shop, Tai Chanam. Later they left. It is not a fact that myself and Tai Chanam were consuming liquor at the shop. We repaired the shop from 9 p.m. to so-and-so, where street lights are nearby. It is not a fact that I stated before the police that myself and Tai Chanam came out of the shop due to hot weather and were sitting near Senki View.
It is not a fact.
Yes, doctor.
That I stated before the police.
Myself,
but then he stated before the police.
Yes.
Right. Hot word, whether he
Yes.
stated before, whether he denied.
Yes.
It's not a fact that we had argued.
Yes. And it is not a fact that they argued at the first Langpu Take. It is also not a fact that while arguing, Tai Shanam had pushed accused Langpu Take, though the accused had come in a white motorcycle, but I did not see its registration number. It is also not a fact that the accused Langpu Take did not inflict cut injury on Tai Shanam. I had seen the dao. It was an arm length. I did not see the Tai Shanam and the other boys drinking in the shop when I went there.
Here at least some contradiction is brought.
Yes, Lordship.
But not the first part.
Yes, Lordship.
That he came to repair and all, and then.
Yes. On the...
Police is examined.
No. So, IO is still given his evidence on Your Lordship. 12/8/2025.
So contradiction is Brought on record, not.
Yes, yes.
So this contradiction, Ms. Ginny, I can see that some contradiction is placed. As
Absolutely.
far as this.
But then, yes, Your Lordship, can this contradiction toward the very incident that he is a named FIR, a person of FIR, Your Lordship.
No,
The place
he is
of
not the
occurrence.
name FIR. If
The
you
place of
go through
occurrence.
The FIR, the accused person's name was not there. He is not the named accused person. And it-
Anyway, we need not go into that.
The place of occurrence is same, Your Lordship. The action of the respondent, how he has attacked the victim are same, Your Lordship. We cannot run away from that, Your Lordship. These are the contradiction that has been given are of a very minor nature, Your Lordship. Can that toward the entire depositions of the victims, Your Lordship. Lordship, I have given the judgment. I'll just rely on that, Your Lordship.
Okay, yes, yes.
I would like.
This thing.
Yes, Your Lordship. This is no, Your Lordship. AG versus Shiv Kumar Yadav and another, Your Lordship.
Oh, yes. Yeah, AG versus.
Yes, Your Lordship.
I read the name of the honorable judges.
Yes. Even in this case, Your Lordship, the recalling of the IO was called for, and one of the reason given was the change of counsel, Your Lordship. Now, while dealing with the case, Your Lordship, at page second last page, paragraph 27, Your Lordship.
Yes.
If I may read, Your Lordship, 27, Your Lordship. It is difficult to approve the view taken by the High Court. Undoubtedly, fair trial is objective, and it is the duty of the court to ensure such fairness. Width of power under Section 311 CRPC is beyond any doubt. Not a single specific reason has been assigned by the High Court as to how in the present case recall as many as 13 witnesses was necessary as directed in the impugn order. No fault has been found with the reasoning of the order of the trial court. The High Court rejected on merits the only two reasons pressed before it, that the trial was hurried and the counsel was not competent. In the face of rejecting these grounds without considering the hardship to the witness, undue delay in the trial, and without any other cogent reason, allowing recall merely on the observation that it is only the accused who will suffer by the delay as he was in custody could, in the circumstances, be hardly accepted as valid or serving the end of the justice. It is not only a matter of delay, but also of harassment for the witnesses to be recalled, which could not be justified on the ground that the accused was in custody and that he could only suffer by prolonging of the proceeding. Certainly, recalling would be permitted if essential for the just decision, but not on such consideration as has been adopted in the present case. Mere observation that recall was necessary for ensuring fair trial is not enough unless there are tangible reasons to show how fair the trial suffered without recall. Recall is not a matter of course, and the discretion given to the court has to be exercised judiciously to prevent failure of the justice and not arbitrarily. While the party is even permitted to correct its bona fide error and may be entitled to further opportunity, even when such opportunity may have been short without any fault on the part of the opposite party, plea for recall for advancing justice has to be bona fide and has to be balanced carefully with the other relevant consideration, including uncalled for hardship to the witness and uncalled for delay in the trial. Having regard to this consideration, we do not find any ground to justify. Then I'll rely upon paragraph 29, Your Lordship. We may now sum up our reason for disapproving the view of the High Court in the present case. The trial court and the High Court held that the accused has appointed counsel for his choice. He was facing trial in other cases also. The earlier counsel were given due opportunity and had duly conducted cross-examination. They were under no handicap. No finding could be recorded that the counsel appointed by the accused were incompetent, particularly at back of such counsel. Expeditious trial in a heinous offense, as is alleged in the present case, is in the interest of justice. The trial court as well as the High Court rejected the reason for recall of the witness. The court has to keep in mind not only the need for giving fair opportunity to the accused, but also the need for ensuring that the victim of the crime is not unduly harassed. Mere fact that the accused was in custody and he will suffer by the delay would be no consideration for allowing recall of the witnesses, particularly at the fag end of the trial. Mere change of the counsel cannot be a ground to recall the witnesses. There is no basis for holding that prejudice will be caused to the accused unless the witnesses are recalled. The High Court has not rejected the reasons given by the trial court, nor given any justification for permitting recall of the witness, except for making general observation that recall was necessary for ensuring fair trial. This observation is contrary to the reasoning of the High Court in dealing with the ground for recall, that is, denial of fair opportunity on account of incompetence of earlier counsel or on account of expeditious proceeding. There is neither any patent error in the approach adopted by the trial court. Now, even in this case, Your Lordship, there was not, this is not a case that the defense were never given an opportunity, Your Lordship. They were given an opportunity. The trial closed, the deposition of both the prosecution witness 2 and 3 closed in the year 2016 and 2018, Your Lordship. Even if a very prompt action was taken at that point of time within a very short period, that could have also been taken as a ground, Your Lordship. But after a period of delay, Your Lordship, this is nothing but then prolonging the trial, Your Lordship, otherwise. And it is not even a case where there are major contradictory, Your Lordship. The facts remain the same, Your Lordship. The incident prior to that, they were sitting in the shop or sitting in the teen alley is different to the second story of the prosecution, that after they parted ways, Your Lordship. That's when the incident happened. After a half an hour, he came back in his bike and then assaulted. This remained collaborative of both the PW2 and PW3, and they are still, even in 161, after half an hour, they were assaulted by the accused, is corroborative, Your Lordship. The prosecution witness has not moved out of that, Your Lordship. There was a fair chance given to the accused, Your Lordship.
Yes.
And therefore,
that is why I
Let her finish.
Therefore, Your Lordship, my humble submission is that the impugn order that has been challenged, Your Lordship, the trial court in no manner has, in any manner, arbitrarily dismissed their petition, Your Lordship. The ground given is very clear, Your Lordship.
Okay.
My Lordship, may I
You're
continue?
finished, you're over.
Yes, Your
These are
Lordship.
the judgments.
Whatever my learned friend has stated before this honorable court, I want to counter that, my lord. Unduly harass and hardship. Whatever my learned friend by submitting the judgment stated that unduly harass and hardship. However, my lord, we are ready to bear the cost of the said victim as well as the independent witness is concerned. We are ready to bear the cost if they are recalled to re-examination at the re-examination. Moreover, Your Lordship, fair trial and essential decision and ends of justice, my lord. We preferred it said recall petition for the ends of justice, my lord. I am not praising that changing the advocate, changing the engaged counsel regarding accused person. I am not pressing on that. However, I place before this honorable court that kindly for the ends of justice, Your Lordship, we want to cross-examine the re-examination of the said victim as well as the PW3, the independent witness, my lord. And for that expeditious trial, my lord, that case was charged sheeted in 2015. If they are so-called, they are conscious, they are concerned to expeditious trial, then it should have been closed within a time frame. However, my lord, in COVID-19, so my lord, at the time of COVID-19, the courts are closed. And moreover, Your Lordship, after COVID event,
They could have ended it much before.
yes, Lordship, if they are concerned about expeditious trial, that could have been finished it earlier even. And moreover, the said PW4 has already been examined in the year of 2018. 2018 to 2015, 7 years has already been gone. But the said IO who has submitted the charge sheet in connection with this case, he is not before the honorable court for cross-examination or he's giving his evidence. My lord, I prefer this petition for the ends of justice, my lord, and moreover, whatever the facts of this case, already Your Lordship has gone through and find that so many contradictions are there. Moreover, I cannot place it that these are the contradictions, these are the before this court in front of my learned friend. So, my lord, at least give us an opportunity on one date. We are closing that re-examination and recall
The
of this.
parents of the victim is examined.
Yes, Lordship.
And it's
He is
there
the
in-
complainant of this case.
And you have annexed those.
Yes, Lordship.
No, whether the mother or the father had said that Rahim Ali had shouted and we had gone out, or they had come to my house.
No, Your Lordship, I have to go on through that.
Yes, Your
Okay,
Lordship.
I'll go through.
It's at page number 22, Your Lordship.
Page number
22, Your Lordship.
22. Yes, he was having it.
I am the informant, may I read, Your Lordship?
I heard sound of my victim's son. I heard sound of my victim's son.
Yes. No, your lordship, page number.
Tai Chanam, she's grandmother or what?
No, your lordship, he is the father of.
Father of the victim, your lordship.
Tai Chali, your lordship.
Tai Chali is the father of the Tai Chanam.
Tai Chanam, your lordship.
Of my son, it should have been. My son shouting, katta hai, katta hai. But this is my victim sound, not Rohim Ali shouting.
Yes.
Oh, achha. Do you have anything more to say? No.
Lord, I have already placed before this honorable court, at least for the ends of justice, my submission.
I'll look into even that intermediate thing we'll see.
Yes.
I'll look into and I'll pass my judgment in the chamber. You'll get it tomorrow, day after.
Yes, lordship. However, my
Definitely. I'll take it
submission
into
before
account.
this honorable court, the maintainability of this petition, because my lord, I have challenged the order.
Okay.
I
482
have,
is there.
yes, my lord.
Okay. Yes. The court master will see.
Tomorrow this will be listed.
Which one?
Item 24.
24.
Yes. The order.
Order matters, right? Order matters I should have taken up no time. 24, okay, listed tomorrow then in supplementary list. Okay.
Lordship,
Oh, I can sit after the references. Okay, I'll take up the order matters once I am through. Okay,
My item is 17.
it's okay. Yeah, I'll come back.
My lord, may I make mention?
Yes.
Item number 29 and 30.
Which one?
Item number 29 and 30.
29 and 30.
30, yes, my lord. May I pray for list this matter on 25,
25th.
25th?
Today is 20th, so day after tomorrow.
Yes, my lord.
29, 30. This is the IA is also for suspension.
My lord, we are hearing on main case.
Okay.
We had hearing also.
So let the entire matter get disposed of.
Yes, my lord. Let this matter be fixed on 25th.
Okay.
And other prayer, my lord. This is the second time that the matter could not reach for hearing. So can this matter be fixed after motion matter?
Day after tomorrow is again a motion day. Or there is no hearing day here.
Just after motion matter, my lord.
Okay.
Just
You make a mention in the morning so that I can take it up.
just after motion matter.
Just after.
your lordship, if
All
I,
I mean motion matlab first in the hearing.
Motion means few cases would be there in a motion thereafter.
I'll take it up as a first hearing matter.
All right.
your lordship, if I may pray,
Okay.
your lordship. So, your lordship, if I may pray, your lordship. If this matter is fixed on Monday, your lordship, 25th, because we as per the we also put our case according to the dates, your lordship. It becomes overburden, your lordship. If your lordship, Monday.
My lord, Monday.
Because this
which
case
day-
has been
day is which day?
Monday will
That-
be 20 something.
30.
30.
Yes.
30.
Yes.
Monday, okay. Today is Monday. Next Monday we can take it up as a first hearing matter.
Yes.
Okay.
So 29, 30 you write as prayed for by Mr. Kago Jaja.
No, S. Koyang. S. Koyang.
S. Koyang. Mr. S. Koyang appearing for the appellant. List the matter on 30th of June 2025. Okay. Monday we will try to get it disposed.
May my lord?
Mentioning.
Yes,
This is actually not the time to mention.
Yes.
These are also for that matter. Yes, but what
my-
it is?
My lord, I would like to mention item number 22.
22.
Yes.
22 is the order matter. I'll take up. Just wait for some time. Okay.
Your Honor, my senior counsel is sick.
No, it's okay. Why is the matter listed for orders? Let me see and you just stay for some time. It will be done. Okay. Oh. orders, there must be some official thing has to be done, like fixing a note. So let the matter come up. I'll take up the order matters now. There is time. Okay? Item number 17. 17.
May please, Raj. 482 application, madam.
And
Bail connection? Yes.
Okay.
For pre-arrest bail. In connection of usually PS case number 95.
Your lordship, CD was called for your lordship. The IO is on leave, your lordship. He have got
it is not here.
Not available, your lordship.
Kindly go through the last order, 11th of 6, my lord. Only hard disk matter, last occasion.
Last order is on
Yes.
11/6.
Yes, and it's already hard the matter, and the honorable court give the assurance that the interim protection may be given in the next day. It means today.
No, scan copy of the case diary was
Yes.
called and then notice interim on the next date.
Yes,
fixed. This is it. But this interim order on the next date means upon
Yes,
perusal
my-
of the case diary.
Yes, my prayer is that, my lord,
Huh.
I am shocking surprisingly when the police has visited my house on
Acha.
26th of May.
Acha.
And suddenly we are very next day came from Guwahati to engage through Engage Council to obtain the certificate copy. When I got the certificate copy, and entire facts is coming out that some allegation is made against me in the year of 2019. FR was lost in 12/6/2019. Now you know, kindly see 25 middle of 25. After 5 years back, they are not filing the charge sheet against me. And allegation is that kindly see my page number 15 in the FIR.
FIR is of 2019.
Yes,
your lordship.
6/12/2019. Page number 15. Yes, Mary.
No Borua.
Yes.
So you are appearing for Anup
Anup
Borua.
Borua, yes. First of all, presently I am residing in the middle of Guwahati, Gitanagar, and alleging my the affair is alleging against me that Mary, my lord. The affair lost before the authority against Sri Anup Borua, who has seated me and some of the customers. He is serving sales executive in Itaford, Ford dealer. He has committed criminal breach of trust, fraud, cheating by forging and using the dealer money received without my consent and misappropriating the money of the company. Hence, the authority of the concerned may initiate necessary criminal proceeding against the aforesaid person by immediately detaining the person mentioned above the book under relevant section of code. It is informed you on 2/12/19 at around 9 a.m. one of my staff furnished a copy with money received of Itaford dealer amounting rupees 50,000 and rupees 17 lakhs respectively upon inquiring about the matter. It was found that Sri Anup
What
Borua.
did it say? One of my staff furnished a copy with
Yes.
money receipt.
I don't know why is he given the statement. My staff furnishing a copy with a money receipt
Okay.
of Itaford Ford dealer amounting rupees of 50,000 and rupees 17 lakhs respectively. Upon inquiring about the matter, it was found that Sri Anup Borua has used the company's money receipt book and used it in a concealing manner for personal gains. The company money receipt, it's very important, my lord. The company money receipt from is kept with the accountant, but how it can in his hand, it is not known. Apart from that, one person also made the complaint that he has paid 4 lakhs in the personal account of Anup Borua to obtain a card EcoFood, but after transferring the amount, he fed away. There is no further report in this concern. He is misusing the company's name and my reputation. At present, he is in Guwahati. These are the allegations. My lord, kindly see.
This is 2019.
2019, 6 FR lodged in 2nd of February and it is registered on 6th of 12. Your Honor, when I got the certificate copy, immediately I know that 7th of January 2020, the Honorable CGM Court of UPA issued the NVW against me.
Gotcha.
And subsequently, when I gone through the order of the record, then it clarified that 2nd of May 2025, Honorable Court given a direction to the concerned police why he is not filing the charge sheet till now. And that is fixed coming 21st of July 2025. My lord, at that time, first of
And
all,
what is this order 7/1/2020?
7, yes, I am annexed.
Why NBW?
Yes, NVW issued on me against me on 7th of January. Kindly see the page number 17. And on that part, Honorable Court, as prayer of the IO,
that honorable court issued the NBW against me. I am misleading the money, so that's why they are as prayer of the investigation officer. Honorable court issued the NBW against me. Page number 17 and 18. Now, my lord.
He has absconded. It is the duty of the police to search by any means.
Yes,
And if he is not found, he will be shown as an absconder in the charge sheet.
absolutely.
This is an order by the
KGM.
Yes,
Yes.
yes, your lordship.
And
I'll just come
Where
to
is
that.
the requirement, huh?
I'll just come to that, your lordship. Your lordship will see that the FIR was filed on 6/12/2019, your lordship. 1 month after, your lordship, a prayer was made for issue of NBW, your lordship. Now, if this was issued, therefore only the CD was required was that if after NBW was issued, was he declared a proclaimed offender or not? Was it for the purpose of declaring him as a proclaimed offender, the NBW was issued?
Once police cannot declare him as an absconder.
Yes, yes,
Only by the court.
Therefore,
He will show him
yes,
in reading
yes.
that he is an absconder.
And my lord.
In the charge sheet.
No, your lordship, no, your lordship. What I'm trying to bring to your lord's knowledge is that prior to declaring him as a proclaimed offender, your lordship, there has to be a permission before the magistrate to issue an NBW. Once NBW is not being executed for a certain period, then the next step is to declare him as a proclaimed offender, your lordship. Now, this order was in the year 2020, your lordship. We are in 2025, your lordship. Now, therefore, the CD was called for to look into the record that if he was after NBW was issued and he was not arrested, the NBW was not executed, and later on an application was made by the IO for declaring him as a proclaimed offender. If that is so in the CD, your lordship, he is precluded from approaching before this honorable court for anticipatory bail as per recent Apex Court's order of
First of all, my lord.
No, do one thing, because this copy was already called for. Without the case diary, I cannot hear on the interim prayer.
My lord, let me explain, my lord, for 2 minutes. Question is that I am at that time absconding or not. Main thing is that FIR is lost in 6/12/2019. But later on, I am still working. I am working that dealer not as a sales executive. As per allegation of the FIR, he stated that I am a sales executive. Not, man. I am just as a consultant of the dealer. My work is to obtain the report and submitted the report directly to the dealer, not any financial related, not any customer. Because the whole
As what?
as a consultant of the dealer.
Consultant.
Yes. And subsequently, my lord, my work is to obtain the document and report to submit the report to the company directly, not the account department. Because whole the transaction financial are looked up by the account department. And most important thing is that I still, in the last part of December, till I am working at the dealer, because honorable court knows very well, in the year of last part of 2019-20, the COVID pandemic destroyed the whole world. And honorable court knows very well at that time, port company left away due to their non-selling and financial problem. Already they are ready to leave the Indian. But my lord, they are not paying my salary and other also employee. So how can I survive? And my lord, most important thing is, if I am absconding, my rented house in Arunachal, FIR is lost in 6/12, I am still aware and residing in Arunachal. So definitely police have the opportunity to collect my addresses.
Steps they have taken, let me see. And reserve your argument for the next day.
Yes,
Wait.
yes, yes.
I mean, I will not give a long date. From where the charge sheet will come?
Nearly,
Nearly.
Yes.
Nearly will not be very far.
It's not far, but your lordship, the IO is on leave, your lordship. I had just spoken to that WT messages.
My prayer is kindly, I may be protected because I may be arrested any point of time. Because
Let the case diary be produced next week.
Your lordship, I had just also intimated the OC, your lordship, to get the. He has just informed me that since this IO is also on leave, he has not handed over the CD to any of his colleagues, your lordship. I mean, therefore, there is difficulty. Otherwise, your lordship, why the CD is needed? Only for the reason that what step was taken after 2020. Even otherwise, if the NBW till date, this is the situation, your lordship. Your lordship is well aware of section 72, your lordship, that execution has to be done before the nothing more than that. Only on the perusal of CD.
Anything, whether
my
it is all done.
humble prayer before the general report, the FIR was lost against this, but not disclose anything. What is the sources of the 17 lakhs rupees? Who paid to me? Who paid to me 6 lakhs?
Sit and
Yes,
saw.
and my prayer is kindly protect me till the next day because I am residing in the middle of Guwahati. Gitanagar police station and my house is only 100 meters. Only 100 meters. And the Arunachal police visited me with the help of the Gitanagar because I have no any criminal intention in earlier, but I have a small family. My minor daughter is there. My old parents. I am the only young member.
It's 2019, you are
Yes.
out. And
I have not absconding because I don't know anything.
Yes, you have not been arrested.
Yes.
Rather. So wait for a few days. Let the case diary come. I'll see. AB, I can issue orders.
No, my
So let the case diary be called
On 3rd of July, Your Lordship.
3rd of July.
third is not possible, my lord.
3rd
This
of
is
July.
Thursday, Friday. I'll be going off. So let us
Thurs-
take it up on 38.
38, Your Lordship, as I have already pointed out, Your Lordship. Since I'll make sure that I try to get the CD, but then as for the information on telephonically informed by the OC, Your Lordship, since he has not handed over the CD, Your Lordship, it would
In
be difficult
previous
on our
occasion-
part.
He is on 15 days casual leave, he said.
Yeah, on from 19th.
From when?
19th.
So
Till then, my lord,
19th of this month. So, okay. Oh, not many days.
Yes, my lord.
13th is the 14th days, Your Lordship. I'll try to.
No, you do one thing. He cannot go without
Yes.
handing it
Yes,
to
yes.
someone.
Yes.
So tell him to hand it over to someone and
Yes.
get it on Monday.
Yes.
Tuesday.
Okay. Yeah. On Wednesday, Your Lordship, in that case, on 2.
I submitting before your mail because kindly protect me because I am come from Guwahati.
You have not been arrested till date.
No, no,
so why
it's
the
police
fear?
visited my house. So I may be arrested any point of time. Because I am coming from when I got the certificate copy. Kindly see the certificate copy. 26 police visited my house and 27 I got the certificate copy. Kindly see the certificate copy page number 80. Yes.
Try it on Monday, Miss Ginny. Ginny, try it on Monday.
Yes, Your Lordship.
Try it on Monday. Monday, you wait for another. They will not take you inside. Okay. Heard Mr. So-and-so?
RK Nath.
Yes.
RK Nath. Already my name is not reflected, but Honorable Court already last the prayer in the order. Till now not mentioned.
Heard Mr. R.K. Nath,
Yes.
learned counsel for the petitioner, and Miss Ginny. Ginny, the first name is what? Topi Ginny, the learned additional public prosecutor for the state of Arunachal Pradesh. It is Miss Ginny states, submits before this honorable court that the by way, and she has also placed one WT message which states that the IO, the investigating officer who is dealing with the instant case, is on leave from 19th, is on leave for 15 days from 19th of this month. And since the said investigating officer has not handed over the file, to any other officer, she has prayed for some time to produce the case diary. Prayer is allowed.
Your Lordship, if I may, just for the convenience of both the parties, Your Lordship, since the non-bailable warrant was issued by the magistrate, this capital complex, Your Lordship, even the record may be called for scanned copy of this record, Your Lordship, at page number 17, Your Lordship. So at least we'll get an idea as to if the non-bailable warrant was executed or not, or what was the consequences of this.
The last occasion scan copy of
Yes.
the case
Right.
record along
Yes.
with case diary.
Yes.
Okay. So you write scan copy of the case record along with the case diary. Okay. Huh? And Mr. Nath.
RK Nath. Yes.
Mr. Nath, however, vehemently objected to the said prayer and said that matter has been delayed
Yes, ma'am.
for a very long time and that he needs an interim protection in the instant matter. Consider the prayer of both the sides. By considering the prayer of both the sides, this court fixes the matter on Monday for perusal of the case record along with the case diary. And if the said record is not placed or produced on Monday, this court would be constrained 2 would be constrained to pass necessary orders as required for the ends of justice. Okay? List it on 30th.
30th, Your Lordship,
30th of June.
30, my lord.
Your Lordship.
I have another matter in Guwahati High Court, ma'am. It's very difficult.
Then first.
29.
29 is a
29.
Sunday.
Sunday.
First of
July.
First. Or you can appear through VC.
Your Lordship,
First
this
of July.
case record, scan copy of the case record from the trial. I'll just write the case record and give it.
Scan copy of the case record from this court.
CGM, capital UPR.
CGM Capital Complex at UPR.
Deeply of them.
And case diary you will bring.
Yes, Your Lordship.
The case diary, scan copy of the so-and-so from UPR, and the learned additional public prosecutor should produce the case diary related to the said case. Okay?
Deeply.
And I'm very happy, ma'am, to appear before DGM. Master bless.
Hope something happens on Tuesday. Why is this fixed for orders today?
My lord, I am appearing on behalf of Dicky Pangan, the leading counsel for the petitioner.
T. Daring.
Dicky Pangan.
Dicky Panging. Okay.
We have taken steps upon respondent number 2. However, the service report is still awaited.
Has not received.
Kindly allow us to take fresh steps.
Okay. Heard Mr. You are?
O Pangam,
Your name is not there.
not reflected.
Heard Mr. So-and-so appearing on behalf of Dicky Panging, learned counsel for the appellant. It is seen from the office note that the service report in respect of respondent number 2 has not been received till date. Seen from the office note dated 26/25. Let's give the date 26/25. Not been received. The learned counsel appearing for the petitioner as such prays that he would take fresh steps for service of notice upon respondent number 2. Prayer is allowed. The petitioner may take steps for service of notice. This is what? POXO matter?
No, yeah, 302.
302. 302, otherwise is not required. Informant is not required to be a party. You have taken, it is awaited. Right. When did you take service report is?
Please, Your Lordship.
So, yes.
Your Lordship, so far as the Deepak Nayak case is concerned, it is concerned with the POXO matter. However, Your Lordship, the Jagdish Singh matter, it's a deal with the general law. So, Your Lordship, we are not praying for the impleadment, but notice has to go. At least the participatory right is there. It has been recognized by the law. So, Your Lordship, so for in the offences which are heinous in nature, if it is 302, then Your Lordship, the party must be given an opportunity, Your Lordship. For that notice has
They have the opportunity of hearing.
Yes, Your Lordship.
For participatory rights.
Yes, Your Lordship.
But otherwise, serving notice upon them is not mandatory.
Your Lordship, but the
By
question,
Guwahati High Court rules.
Your Lordship, but the question, Your Lordship, the prior to the Jagdish Singh matter, Your Lordship, there was no such aspect was there. But Your Lordship, the issue here is, Your Lordship, during the trial, they will get a notice or their presence is the certain provisions are there under the court, Your Lordship. But during the appeal, Your Lordship, there is no any such provision as such. Only the court has declared that they have a participatory right.
Yeah.
But Your Lordship, that participatory right they can exercise only when they will have a knowledge that okay the case is
That's what, yes.
Your
They
Lordship.
have to have the knowledge.
Yes, Your Lordship.
But since they are the informant,
Not your informant implement is not notice is not required. Victim family actually, madam.
this is not POXO. This is 302.
Yes, Your Lordship, absolutely. The informant is not necessary can be victim, but victim can be
Here
informant.
the
Yes, Your Lordship.
informant is victims who? I mean, who is here the informant is in what way is related to the victim?
That has to be looked into, madam.
Uh-huh.
That has to be taken into consideration because informant implement is not required. But if informant itself is victim or is belong to the victim family, or even if it is not under POXO Act, because Your Lordship, CRPC or the BNSS section 2, the victim definition is clearly be
enumerated, given there, your lordship. Victim include the victim family or the legal heir. So not the informant, but the victim family member, either of the victim.
Since the notices have gone, fresh notice is not required. Let us await.
Yes, await for the service report.
Because you have taken you have taken steps on 22nd of January. Okay, fine. You take fresh notice. Otherwise, it's not required. But then it's okay. What did I say? Of notice upon respond number 2 by registered post with AD within a period of 3 days from today. Let the matter be listed after 3 weeks.
Or your lordship may direct them to take step through jurisdictional PS, your lordship. That is the.
It's be done. Or
that is the.
Also, it is done. But then, unless it is POXO.
Yes, your lordship.
This is not mandatory that.
POXO matter, your lordship, it clearly delineated in the Deepak Nayak case, your lordship. But your lordship, Jagdish Singh matter. Otherwise, your lordship, Bormoti Pangin case was also there. And this later on Jagdish Singh matter came, your lordship, wherein even all this, no, the specific implement thing has been discussed. But since this court has held that the participatory right, now the question here is how they will participate if they don't have the knowledge, your lordship.
It is okay.
Yes.
It is their duty to also find out what had happened to his case.
Yes, yes, your lordship.
So since it is not made mandatory, we cannot just make it mandatory now that they have to be served.
Yes, your lordship, absolutely. Implement, your lordship, we are not playing. Your lordship, the coordinate bench of this court has deal with this aspect in anticipatory way, wherein the parties has filed an IA for implement. But referring to the Jagdish Singh matter, the court has held that implement is not required, but notice can go, your lordship, because it even flow from your.
If he is not implemented, then how can the notice go?
Your lordship, the same aspect has been dealt in the Delhi High Court case. Your lordship, the Deepak Nayak case. In Deepak Nayak case, implement has been made as mandatory, my lord.
This is
But,
POXO.
yes, but in your lordship will find in the other cases also, the Delhi High Court, it has been taken as mutati mutandis, wherein your lordship, it has been held that the 439 subsection 1A, it doesn't say the implement, it says obligatory for their participation. So the notice has to be go through the jurisdictional police station. Implement even without the implement.
No, what about our Guwahati High Court rules? It is amended, not required, not mandatory.
In your lordship, present Guwahati High Court rule, even in 482, even appeal against acquittal, your lordship, implement is not required. I've gone through the new amendment, your lordship.
Yes, so even implement is required, where is the question of service notice?
Yeah,
Notice.
that your lordship, that issue is there in the new.
Because informant or the victim, what right he has? He has to assist the public prosecutor.
No, your lordship.
301.
No, my lord, that expect.
Written argument.
No, my lord, that expect has been held in the, they are not auxiliary or auxiliary to the public prosecutor as held in the Jagdish Singh matter. They must be,
Judgment overrule the statutory provisions. It is writ large in 301, they can only assist.
Your lordship, that aspect also, your lordship, has been decided that during the trial,
Go with the statutory right. Where is the, what is the judgment you are talking about?
Your lordship, Jagdish Singh matter.
Give me the citation.
It's 2022.
This is Purana.
But
This is before the notifications, before the High Court rules. High Court rules is amended 24.
Yes, your lordship, in the High Court rule, your lordship, that is what I'm trying to point out.
Right is there, but he has implemented him as a respondent. Notices have gone and no need for fresh notices. If nobody comes, we will proceed with the appeal.
But your lordship,
The laws.
yes, if it is served and if they do not turn up, your lordship, then court can presume that they don't want to participate the proceeding, your lordship. If notice is
make it mandatory when it is not mandatory.
my lord, my lord, may kindly allow me to read that operating part of the judgment, my lord.
This is again before everything. This is 22 judgment, no?
Yes, my lord, and recently in the one more judgment, your lordship, wherein by our own coordinate bench by Justice Goswami, your lordship, in Pratik Jain matter also, your lordship, the court has held that the inroad has been made by the judicial precedent, my lord. Although the statute doesn't provide, but through judicial inroad, that participatory right has been recognized.
Participatory rights is recognized everywhere. But then the service is not mandatory when it is not a POXO case. Since they have only participatory rights and they can assist the public prosecutor or can file a written argument. But
Yes, your
nothing
lordship.
more than that.
On your lordship, that aspect, your lordship, so far as the participatory right is concerned, in Jagdish Singh it says, not in the trial matter. In trial part also the judgment is there. In trial, they can only assist the public prosecutor under 301 of the CRPC, now corresponding to the provision of the BNC. But now, your lordship, in the bail, before the, your lordship, in bail, the things has been through judicial inroad, your lordship. That I'm trying to, your lordship, read out. Your lordship, can allow me to read.
In some other matter,
Okay, your lordship.
I can go into that. Now that he has said that he will take fresh notice, okay. Fresh notice upon respond number 2. Then after that, what did I say? I got it. Yeah.
Oblige.
May I, my lord?
Yes.
My lord, I'm appearing on behalf of SK Diori, the conducting council. We have taken steps, but there is service report is still awaited.
Service report in respect of respond number 2 not. So
We may be
fresh-
allowed to take Dusty.
Dusty. Dusty is not recognized in criminal law. This is
I was,
criminal petition, right?
yes,
This is
I was
not a
instructed to
civil-
ask for that.
You take fresh steps through the, what is this matter about? Huh?
Lordship, I'm partially aware with the matter.
Acha.
This morning only I was advised.
This is washing and setting aside of criminal proceeding. Okay, right, Mr. So-and-so,
He comes,
appearing for the petitioner,
He comes. Comes, sir.
and Mr. Ete for the learned additional public prosecutor for the state of Arunachal Pradesh. It is seen from the office note dated 19/6/2025 that the service report in respect of respond number 2 has not been received from OCPS Changlam. It was already made through the OC, officer in charge of,
Yes.
once it is UPR, then again Changlang. Let the so-and-so, you will take fresh steps?
Yes, Lord.
Mr. So-and-so has prayed before this honorable court that he may take fresh steps for service of notice upon respond number 2. Prayer is allowed. List this matter after 3 weeks.
Oblige.
Again, service on R2 awaited.
Yes, Your Lordship, it's been quite a while that the service has not yet been completed upon the complainant. And he's actually just an informant who, to whom the victim had gone. Merely on the basis of that complaint, he had filed the FIR. So he has given a statement also before the learned trial court that he does not know anything about this case except for the fact that the victim had come to him and had and thereafter he had registered the FIR.
Or respondent number 2 is how he is related to the victim?
He is the chairman of the CWC department. CWC.
So otherwise he has no role.
Otherwise he has no role to play.
This is under juvenile justice.
This is under. This is yes, Your Honor, because there are allegations that the accused persons had deprived the victim of food and like they had mistreated her. However, in
So otherwise, the notice should go to the victim, I think.
Your Honor, in this case, what has happened is the victim cannot be found and she has been dropped by the prosecution. So the matter is merely pending because of because the victim was not appearing before the trial court. So now, since the victim has also been robbed by the prosecution, merely continuing this proceeding before the trial court would be an abuse of the process of court, because there are no other evidences against the accused persons. That is why we have come before this honorable court for quashing of the FIR and the proceedings.
But without a victim, there are no evidence at all.
There's no eyewitness, there's no other corroborating evidence. There are witnesses who have deposed before the honorable trial court, but then there's nothing that can be made out from their evidence as well.
But then let's see what the CWC person say. Why the services cannot be served, notice cannot be served upon him? He is otherwise the chairperson CWC Sonitpur Sahitya.
Yes, Your Honor.
But he is no longer the chairperson now.
I have no idea. On the last occasion, we had made an attempt to make the service possible through the OCPS as well, but that has also not been done. So,
Your Lordship, we are yet to receive any report from the concerned police station, Your Lordship.
Yeah. But it was not through the police station, it was through the office of the PP, UPR.
Yes, we know the usual process is once we get the service copy, we give it to the jurisdictional police station.
Like it is done in POCSO.
Yes, Your Lordship.
So you try to find out.
Yes,
get
Your
the
Lordship.
instruction.
We have already given the notice, Your Lordship. We are yet to receive the report.
Okay, heard Ms. So-and-so for the petitioner and Ms. Ginny. T. Ginny, additional public prosecutor for the state of Mizoram. Ms. Ginny, the APP has APP submits before this honorable court that although the steps were taken, steps for service of notice was taken through the office of the PP UPR, she is yet to get the instruction from the concerned police station as to whether the notice is served upon the respondent to or not. She as such prays that she may be given some more time to get the instruction. Prayer is allowed. List the matter after 2 weeks. Try to get the instruction.
Deeply. Your Lordship, I am the petitioner in this matter, Your Lordship. This is a civil dispute. We have just received the we have just received
Objection to be filed by respondent number 2.
Yes, I have.
they have filed, Your Lordship.
You have filed?
Yes.
Your Lordship,
Okay.
in that case, may fix this matter on Monday for final hearing, Your Lordship.
Okay.
Admission hearing, it may be disposed on admission hearing, Your Lordship. The issue is very simple otherwise, Your Lordship.
Okay, fine. Well, heard Ms. T. Ginny appearing for the petitioner. And Mr.
I am for the respondent number 2.
Okay, so for respondent number 2 and the government advocate.
yes, I'm for respondent number 1.
Okay. You are
R. Basar.
R. Asar.
R. Basar.
R.
Basar.
Basai. Basar. R. Basar.
Yes.
R. Basar, the government advocate, appearing on behalf of respondent number 1. On the last occasion, the respondent number 2 had prayed for filing of an additional affidavit, in opposition, which he had filed on 19/6/2025.
Yes.
You have served copy on her?
Yes, Your Lordship.
Okay. Ms. T. Ginny has also stated that she has received a copy of the said affidavit in opposition. It seems that the pleadings are complete and the matter can be heard and can be disposed of. Ms. T. Ginny prays that the matter may be taken up on Monday next, 30th of June 2025. List the matter accordingly.
Okay, for admission hearing, Your Lordship.
For admission here. No problem. Yes.
Your Lordship, in this matter, notice have already served and all the respondents have arrived. If TCR is received by this honorable court, this matter may fix for admission hearing.
As concentrate with
I am for the petitioner.
You're for the
petitioner, yes,
and all others are served.
yes.
How many respondents?
And there are two respondents. One is PP and another one is private respondent.
Respond number 2.
Yes.
So, heard Miss So and so, your
A. Rai.
Rai for the petitioner, as well as you're the additional PP?
Yes.
Yes.
For state.
You're the learned additional PP for the state of Arunachal Pradesh. Where is respondent number 2? Is there? As well as Mr. So and so for respondent number 2. You are T. Tamin.
No, Lordship. I'm Tita Kyang on behalf of Mr. T. Tofu. Due to health issue, leading counsel is out of station today. So, Lordship matter may be adjourned and listed after 2 weeks.
And so and so. Mr. So and so appearing for respondent number 2 submits. That is senior. What problem he had?
Health issue, Your Honor.
His senior had some health issues. So he has prayed that the matter may be taken up after 2 weeks. The same is not objected by Ms. So and so for the petitioner. List the matter after 2 weeks on a date fixed by the registry. It is also submitted at the bar that the pleadings are complete and the matter can be taken up as admission hearing and can be disposed of on the next date. List the matter after 2 weeks.
Much obliged.
Deeply.
Yes. Can copy has been received.
Yes, Lordship.
Hmm.
Lordship, this is a family matter, dispute matter, Lordship, for the causing of FIR, Lordship.
Oh, this is quashing of FIR.
It was actually there are two FIR has lost.
No, today it is for orders, so that the records are received. Or records were called on the last occasion and it is received. So you go through the records and the matter can be taken up, and otherwise the respondent is served.
It's a joint petition, man.
Joint
petition.
It is already compromised, Lordship.
Okay.
So Lordship may be quest today, Lordship. My humble praise. Maybe quest today, Lordship.
No, I have to see this. Now it is already 4:15. So what kind of a settlement you have arrived at, I have to see. And where you are, he is the additional PP and joint petition by both, husband and wife, or what?
Yes, Lordship.
Victim, accused,
You
everyone.
have married or what?
Yes, Lordship.
Offense involved.
Actually, Lordship, two victims are there, Lordship. One victim is a husband, Lordship, and second victim is a second wife, Lordship, my sister-in-law, Lordship.
Achha.
It was
It's
happened.
okay. Look, today it's 4:15. I'll take it up next week or Friday, Thursday, any day.
Lordship may be fixed 25 of this month.
25th?
Day after tomorrow.
Day after tomorrow. Okay.
Yes, Lordship.
Due to paucity of time, the matter could not be taken up today. List the matter again on 25th
Yes, Lordship.
of June.
Yes, Team Fit, Lordship.
My lord,
Yes.
here, I am for the, my lord, this private respondent number 1, my lord. And so far, my lord, by seeing this private respondent number 2 and 3, since they are the members of the Kebang body who pass the judgment in exercise of the judicial power. So their impeachment is under the law is not proper, my lord, because they are the these 2 and 3, they pass the judgment in exercise of the judicial power.
It is almost like unless bias is there, they are not the
that's
party.
why, my lord, 2 and 3 is not required, that their names may be struck out. So 1 I am representing, my lord. So even 4 has been struck out already. So meaning thereby, my lord, this service is complete. So far this case is concerned.
Trial court trial court orders have not been received.
My lord, this, my lord, is a Kebang proceeding, my lord. So, my lord, unlikely any reports will be there, my lord.
Oh.
So now today, my lord, why I have prayed for listing this matter, basically, my lord. First to apprise this honorable court that this 2 and 3, they being the members of the KEBA, so it is not proper to implicate them in the case, praying for extracting out their name. Thereafter, my lord, what happened? On 21/5/2025, an interim order was passed without hearing. So far, my lord, suspension of the order is concerned. Today, I am not resisting that one. Let it be there. But what the problem has ensued is that by taking under the garb of this stay order, what these petitioners have done, they have forcefully entered into the disputed land, rampantly, completely destroyed all the jungles. They are still doing those things. So my prayer is that today only, my lord, in addition to whatever has been given, my lord, this parties, both the parties, including me, my lord, they should not do any destruction activities or development activities on the disputed land till the disposal of this case.
Already there is an operation of the impugn orders now, and also the impugn judgment passed by so-and-so state.
Yes, this has been stated. Now the petitioners, they are undertaking, my lord, this destruction of all this disputed land. So what I am praying, I am for the respondent, my lord, that I am saying that let it be this judgment be stayed, my lord, only that both the parties should maintain status quo and should not.
No, as of today, it has come up for orders. So why? The trial court record has not been received, and you are saying that there
last
is no...
time I mentioned for listing this one, my lord. So basically, I just want to, because urgency of this, because these respondents, these petitioners, they are undertaking this destruction activities, my lord. That's why I had to make urgent mention and get the matter listed, my lord. Just for only addition that both the parties should not do any activities, my lord, on the disputed land.
But then for that, I have to go through the entire case.
My lord, this is the case, my lord. My lord, will see from the order itself, my lord, 21/5/2025. This revision petition is basically against the, my lord, impugn order passed by the, allegedly passed by the All Parang Circle Gangbura Welfare Association itself. This kind of, my lord,
let the matter come up day after tomorrow or Thursday, Friday. Then I can look into the matter and pass orders, because there is no time now. I'll have to go. And there is already an amended cause title PW number 4 is
our respondent 4 has been struck out.
Okay, you want 2, 3 also to go?
Because I am apprising this honorable court, it is inappropriate to implicate them in the case, since what they have done is in exercise the statutory power only.
But then I'll have to see, because if there is some biasness and all, then they can be made parties. In the official duties, of course, they are not required. So I have to see what allegations they are framing against the Kebang committee.
Now the question, even even if you say the bias, this is not the executive body. So for executive is concerned, my lord, I know biasness we can make the party. So for the judicial part, my lord, suppose some judges pass the order. Can we say by bias?
Same things like tribunal should not be made party, judges should not be made party.
Yes,
unless biasness is shown.
Judges, bias, my lord, even the judicial function, my lord, bias, my lord, this is something. So for executive authorities concerned, it is clear. If we are alleging bias, we can make the party. But suppose, my lord, a judge passes a judgment order. Even if I allege, can I make a party, my lord? I think that is not.
If you allege biasness on their part, then he can be made a party.
Then, my lord, that part we will go through. Let it be there. But today, my lord, because basically I had to make urgent listing of this matter, because it's not going to harm anybody. Already this judgment has been suspended. I am not saying that just to modify it. I am not insisting at this stage, my lord. Only the thing is that, my lord, both the party should not do any activities. Because, my lord, the petitioner is rampantly undertaking the activities, my lord. And when I approach the district authority, they are saying the matter is pending before the High Court. We will not take up the matter. Now it has become very difficult for me.
What is the order which is state? What did the order?
It was the order, my lord. Title right was declared in my favor. Possession was declared in my favor.
Oh, that
has been stayed, my lord. Only, my lord, this will not harm anybody, my lord. Whatever they have done. But onwards, my lord.
Anyhow, I'll have to go through the records. Let the matter come up day after tomorrow, then only. Okay. So due to paucity of time, because unless I see the records, I'll know.
After tomorrow, my lord, I'll be out of station. Tomorrow, my lord.
Tomorrow there will be difficulty. Otherwise, Thursday.
Because urgency is there, because I have become very difficult for me, because I have even filed.
Okay, we can do one thing. You can give an undertaking that nothing will happen in these days until the matter
Lordship,
is taken up.
regarding this, conducting council can only submit. Because I'm not in capacity to argue the matter.
The conducting council is where?
Conducting council is not.
Unless I hear them also, how can I pass
I
this
understand,
Lordship?
but my lord can see from the, because this order was also passed ad interim without hearing me, my lord. But I am saying today, I am not saying for modification. My lord can see the nature of the case, that it's on the record. Declaration, right, title was in my.
No, still I'll have to hear on a
Now,
subsequent date.
This has been stayed, my lord. Now the difficulty is that, my lord, with this stay, it would be more appropriate if the both the parties are refrained from undertaking any activities, my lord. Because the moment he got the stay, he went there.
You file an application then for that order?
That came then, my lord. So I thought, my lord, because this is not going to harm, my lord, anything, or
No,
this is not
whatever
going to
it is,
change
it
the
has-
nature of the nature of the
Has to be
case. Also.
again in a process. So you file an application, small application I, so that it can be heard. Okay. Heard, Miss So-and-so, appearing for the petitioner, and Mr. So-and-so for the respondent number 2. It is stated by your name.
Arsenal.
I tend to forget.
Arsenal.
R. Sonar, yes. Rajesh Sonar.
Right.
Yes, for respondent number 2. It is stated by the council appearing for respondent number 2 that in spite of the stay order of the judgment and order, in spite of the stay of
No,
the
after getting the stay.
okay, in spite of the stay granted by the last order by 21/5/2025, the petitioners have encroached, have what cleared?
They are undertaking destroying all these standing trees. They are undertaking the cultivation over the disputed.
The petitioners have encroached. No, not encroached. The petitioners are destroying the trees which are there on the land on the disputed land. As such, he prays that he may file an application, an interlocutory application for necessary orders. The prayer is allowed. List the matter after a week.
After a week.
After a week.
Lordship, interim. Interim.
Oh, interim is the interim order. I think this is
Till
interim
returnable
order.
date.
Oh, till return executable date. The interim order passed earlier.
That's why, my lord, my
Will
prayer,
continue?
my prayer, my lord. That's why, since it is still returnable date, my lord. My lord, even if extending, my lord, because my last time, my lord, after hearing the petitioner, this interim was granted, my lord. My lord, today it's extending, my lord. Only that aid can be done without even, my lord, filing the application that both the parties should maintain the status quo. My lord is extending the interim order, my lord. At least
Extending the interim order in the sense that the land is not, it has been decided against you, right?
No, my lord. This is where the land was decided in my favor.
The right title interest.
Right title in my favor. Then, by way of this civil releasing petition, the petitioners are challenging their judgment, and their judgment has been suspended. Now, after having got the order from this court, now they are destroying all those things. Their judgment was
In your
in my
land.
favor. my
In
lord.
your land.
Yes, my lord.
It's okay, but then you have to file an application that they are doing so and so. So I need further order.
Still considering the nature of the case, my lord, since today only for the first time, I am also hurt, my lord. My lord, because this is not going to harm anybody, my lord.
No, not harming anybody. It's okay. Then, right, Mr. So-and-so has prayed that he would file an interlocutory application for necessary orders. List this after a week. It's okay. And then interim order passed earlier shall continue until further orders. Okay. Then you may make the application, then it's without there being in prayer, how can I just say that there has to be status? I don't know, 25. It's already 42. 25. This is an appeal.
Appeal.
Lordship may kindly pass over the matter for time being.
Time being?
Yes,
This is the
Lordship.
last matter I'm told.
Then Lordship may pass over for the.
What is this criminal appeal? I mean, against what order? What judgment? Against judgment?
Against conviction, against conviction.
Conviction under what? 304.
No, madam. Under 323 and two sections are there. 323 and
No, it's not 323. It's 304. Oh, yes. 323, 334. Okay, when can you do?
Lordship, tomorrow.
Tomorrow?
Yes, Lordship. Because Mr. Kato is in court number 1, appearing in court number 1.
Okay. Heard me, sir.
my lord, I have objection. I'll go back to home at 0. Tomorrow I'll not available here.
Then when?
So let us have after 1 week.
Okay, Lordship.
Next week?
Okay, Lordship.
After, after a week.
Okay. And Mr. You're for respond number 2?
Yes, 1 and 2.
1 and 2. And you're 3? Yes. This is what? Against acquittal?
Against acquittal. No, against conviction.
Against conviction? So how come there are 2 respondents?
No, 2 accused were there. 2 persons were convicted.
2 persons were convicted?
Yes, yes. Respondent number 1 and 2.
And this is made as a respondent number 3. It is an appeal against for the enhancement of sentence.
For enhancement of sentence?
Yes.
Okay.
Malad,
Hmm.
I'm for the appellant here.
Acha.
I'm sorry, Malad, I was in the court number 1.
Okay.
Malad, everything has been proved beyond reasonable doubt. Malad, the quantum of punishment has been much lesser than the Malad, the provision is contemplated under the Malad, the penal provision, the convict provision.
Oh, it is only for enhancement.
My lord. So, my lord, what happened in this case? The accused person who has already undergone inside the custody, that has been my lord set up, my lord. Before my lord, the charge sheet. He was only for my lord, in the custody for 45 days, man. 42.
Here, the entire matter?
Yes, madam.
Tomorrow, day after, whenever he is some problem.
My lord, this is long pending case. The big statement.
So any day, whatever you suggest?
I have another matter on 30th. Can it be on 1st July?
1st July, my lord.
Okay, Tuesday.
Tuesday.
Due to paucity of time, the matter could not be heard today. And on the prayer of the parties appearing before this court, list this matter on 1st of July 2025.
Madam.
Okay.
Deputy.
Ouch.